From the discussions made above, it becomes clear that on every step there has been an attempt to limit the competition and oust the petitioner. There is a specific argument made that the same has been done to favor certain blue-eyed boys. Though no person has been made party respondent by name, the materials which have been placed before this court and the background circumstances are clear that the petitioner has been sought to be ousted from the competition. As mentioned above, the petitioner had to approach this court even on the issue of site visiting certificate. Secondly, after being adjudged L1, the letter of intent was not forthcoming and therefore another writ petition had to be filed, followed by the impugned communication dated so and so for cancelling the entire earlier tender and going for retender with a new technology, which is admittedly on the intervention of the local MLA. The aspect that the other package of the same contract has been allotted to another contractor on the existing technology is also a relevant consideration. All the aforesaid action clearly appears to be vitiated by malice in law as well as malafide, which clearly does not appear to be fair and transparent. The huge difference in the price bid of the petitioner and the second bidder, which is about 7 crore, is also a relevant factor which is directly connected with public interest and public revenue. In the aspect of distribution of state largesses, fairness and transparency are the hallmarks. The state is mandated to act fairly so that no citizens are prejudiced. The present impugned action clearly appears to be accentuated by malice in law, whereby the rights of the petitioner has been clearly violated. In the conspectus of the aforesaid discussion, this court has no other option but to allow the writ petitions. Impugned order, it is so and so stands interfered with and is set aside. Work in question is directed to be allotted to the petitioner who is adjudged L1 in accordance with law. No order is to cause.
Obliged.
Yes.
My lord, item number 36, my lord. The respondent side had filed their opposition, my lord. My lord, today itself, my lord, I am going to file reply, my lord.
36.
My lord. The matter may come up next Thursday, my lord.
Who's for the other side?
PWD wrote.
You have informed.
My lord, I was calling Vikram, my lord, but he has
No,
not.
no, you have to inform him.
My lord, but he is not receiving the call, my lord.
Cannot help. We have to inform them. Yes.
No, with the concern of the petition number 23, my lord.
Item number?
Number 22.
22,
Taken
yes.
on Friday, my lord. 7th, my lord.
Here for the respondent,
For the
GMC.
respondent, GMC.
On a request made by Sri S. Bora, Learned Standing Council, GMC, matter is adjourned to be listed on Friday. Date, please. 7th only. 7th, 8.
May I submit, madam?
Sri SP Das, Learned Council for the petitioner is present.
Item number 53.
Yes.
Lordship, I was the engaged advocate in earlier in this matter, and petitioner himself conduct the case. And we are already pursued the application before the registry, and also NOC and file return to the petitioner.
Okay.
Kindly deleted our
Okay.
name.
Okay. 53 to Bonat Puriba, 53 to advocate Nathake. 53 had said.
Yes.
53 to advocate Nathake. In person.
Make it your lordship. Lordship, with regard to item number 48, your lordship.
Yes.
Lordship, I'm praying for some time, lordship, to file academic reply, your lordship. I'm taking consent from the IS, council for the IS, lordship.
On a request made by Sri DJ Das, Learned Counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Sri M. Sharma, Learned Standing Council, IOC is present. List on today, Adik Mano.
First week of September, your lordship.
Huh?
First week of September, your lordship.
They're not, then say, don't say 2 weeks, they say 3 weeks. 3 weeks. On request, list on 2nd of September.
Lordship.
2/9.
There's a stay operating in my friend's favor.
2/9. Interim order passed earlier. Stands extended till the next date of listing.
With the consent of the other side, item number 26 minutes.
Hmm.
If it may be adjourned for 2 weeks.
Here for whom?
For J. Abbas.
Petitioner.
Yes, Your Honor.
Why are you seeking adjournment?
The counsel is not here. He is out of station.
Okay, on a request made on behalf of Sri J. Abbas, Learned Counsel for the petitioner, who is stated to be out of station, matter is adjourned to be listed on 26th of August,
Grateful, my lord.
26/8.
May I bill, sir? I think to maximum for listing, Miller. A similar matter is fixed tomorrow, Miller.
Listing for what?
I take usually I'll not furniture house.
Motion.
Motion.
Okay, motion is.
May it please your lordship, similar prayer lordship for tomorrow, motion,
Not to tomorrow. What year is
eviction matter lordship,
eviction?
lordship,
Okay.
obliged.
May I please, Lord? I'd like to mention for, listing a matter and motion for on Wednesday.
May it please your lordship, praying for listing of a fresh writ petition on Wednesday, lordship.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 29, Lordship, for appearing for the petitioner, Lordship. Lord, I seek 2 weeks time to file a written reply against the appeal opposition filed by the CPWD. Lordship.
CPWD
Yes,
by
yes, by-
Mr. Roy.
Yes, yes.
Okay.
They filed the affidavit opposition.
Item number
29, Your Lordship.
29. Your name is not there?
H. Mozumdar, Your Lordship.
Yes, yes. On the request of Sri H. Mazumdar, learned counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Sri S.S. Roy, learned CGC is present. Para. List on 19th of, is it okay, 19th?
Yes, Lord.
19/8.
Much obliged, Lord.
Your lordship, I beg to mention item number 50.
50.
Yes.
Yes.
2 weeks time may be granted as the engaged counsel for the respondent is out of station.
Who is the engaged counsel?
M.
Counsel? Huh?
M. Smith.
M. Smith, oh, for the respondent.
Yes, your lordship.
Taking the consider the other side.
Yes, your
And for the petitioner, Lordship.
Okay. Okay. On a request made on behalf of Sri M. Smith, learned standing counsel, ESIC, matter is adjourned by 2 weeks. Sri R. Sharma, learned counsel for the petitioner is present. Para. List on 12th of August. Is it okay? 2 weeks, no? 12, no, not 12. On 19th of August.
Yes.
19th of August, interim order passed earlier to continue till the next date of listing.
Obliged.
Obliged.
Item number 24 and 25, from the respective deputy commissioner, I have received the instructions. I would like to file the affidavit on behalf of the GC. I prefer some time, I have already prepared the affidavit.
Okay.
Can it be taken on Friday or Monday?
Oh,
My,
Monday? Okay, on a request made by Sri D. Nath, learned senior advocate Assam, matter is adjourned by a week to enable him to file the affidavit. List para on Sri B. Rahman, learned counsel for the petitioner is present. Para on request. List on 10th of
10th.
August. 24 and 25.
24.
10 August. Yes.
But at item 36, my lord, I have taken concept for
36.
next Monday. And file reply. Matter.
He will file reply.
I will file reply today. Matter.
Okay. Sri S. Hawk, learned counsel for the petitioner, submits that the rejoinder affidavit would be filed during the course of the day. Full stop para. Let such rejoinder affidavit be filed and tagged with the records. Full stop. Matter be listed on Friday?
Friday.
Friday 7th hoga na?
Interview.
On 7th. Interim order passed earlier to continue till the next date of listing. 7th. Huh?
Okay.
Lordship, with the consent of the other side, I beg to mention item number 39, Lordship.
Yes.
I pray for some time to file rejoinder in this case.
IOC has filed affidavit.
ISCS filed.
Okay. What is your name?
SK Gupta.
SK
Gupta.
Gupta.
SK Gupta.
You are not on record, Mr. Gupta. On behalf of Mr. Bhatti.
On behalf of Mr. Bhatti.
On the prayer of Sri S.K. Gupta, learned counsel appearing on instruction of Sri O.P. Bhatti, learned counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Full stop. Sri M. Sharma, standing counsel, learned standing counsel IOC is present. Full stop. List on 19th of August, 19/8.
Lordship, for listing of an urgent motion matter, day after tomorrow.
May it please your lordship, with the consent of the other side, I beg to mention item 21, my lord.
Yes.
Lordship, we are going to file our rejoinder affidavit in this matter, my lord. So my lord, make.
How much time is,
Yes, my
madam?
lord, 2 weeks time may be given.
2 is 24 matter. Okay. On a prayer made by Ms. B. Bora,
Lordship.
learned counsel for the petitioners,
Yes.
matter is adjourned by 2 weeks to file rejoinder affidavit. List on the 3rd, 19th of August, 19/8.
May it please your lordship, my lord, in respect to item number 56 of
Hmm.
the lordship's supplementary cause list,
Yes,
they have filed an additional affidavit, my lord. It may kindly call for our records, my lord.
yes, bring it.
It may
May I please your lordship, with the consent of other side lordship, I beg to mention item number 41.
Yes,
Here I have to file my reply lordship will require some time. I've taken the consent
41.
lordship.
On a request made by Sri S. Roy Leonard CGC, matter is adjourned by 2 weeks,
3 weeks.
3 weeks to enable filing of affidavit in opposition.
Lordship.
Full stop. List on 24th of August. 24/8.
Lordship.
Lordship, in item 40, your lordship, we have filed an affidavit in reply that my kind of.
Yes.
May I please, your lordship, with consent of the other side, I beg to mention item 30, my lord.
30.
30.
Yes.
Engaged senior counsel is out of station, so may kindly.
Okay, fisheries in, okay. On a prayer made by Sri DJ Medhi,
Medhi.
learned counsel for the petitioner on behalf of a senior, Sri Didas,
Yes, Doctor.
or Sri, on behalf of Sri S. Datta, matter is adjourned to be listed after 2 weeks.
Lordship, can you give 14, my lord?
For 2 weeks, 2 weeks, full stop. On request list on 14. 8, Miss S. Chutia, learned standing counsel, Fisheries Department is present.
Much obliged.
Yes,
May it please your lordship, lordship, with the consent of the other side, I beg to mention item number 27.
yes,
This is, lordship, we have sent the affidavit for vetting and it will be filed shortly.
taking the consent, Mr. Sharma?
Yes, lordship.
Okay. Shri M. Bhuya, learned counsel representing the Public Works Department, has submitted that the affidavit in opposition has been prepared and sent for vetting. Full stop. He accordingly pays for some time. Para. Also heard Sri P. Sharma, learned counsel for the petitioner. Para. Matter accordingly stands adjourned to be listed on 24th of August to enable filing of affidavit in opposition.
Lordship, it would be additional affidavit.
Or not, additional affidavit.
May I please your lordship, my lord, with the consent of the other side, my lord, I beg to mention item number 13, my lord.
19,
13(1)(3), my lord. Motion matter.
13,
Yes, my lord. That may be taken up tomorrow, my lord, along with the other fixed matters, my lord. 13(1).
13, tomorrow.
Yes, yes. That
Tomorrow those matters are fixed, actually. Okay.
forest matter.
What is your name?
S.S. Ahmed, my lord, on behalf of HRS.
Sri S. Ahmed, learned counsel appearing on instruction of Sri H.R.A. Chaudhary, learned senior counsel for the petitioner submits that similar matters are fixed tomorrow. The lead case being WPC
373926.
3739 of 26. Para. Also heard, you're there, Sri P.N. Goswami, learned AAG Assam. Para. Matter is accordingly adjourned to be listed tomorrow along with WPC so and so.
Hello, with the consent of the petitioner, I beg to mention item number 34.
34, yes.
34. 4 weeks time may be given for filing the counter affidavit.
Counter affidavit. You are for the, you are for whom?
FCI.
FCI. Okay. Taking the consent of the other side. Okay. On a request made on behalf of the FCI, matter is adjourned by 4 weeks to enable filing of affidavit in opposition. Full stop list on, we'll have it on 2nd of August, 2nd of September. 2/9.
Can it be on 23rd September?
23rd?
September.
23rd will be a long time. We'll have it, we'll, if you have a difficulty, we'll see on the date, 2nd.
Obliged. Mr. Lordship, Lordship, with the concern from the other side, I beg to mention item 47.
Item number
47. Lordship.
47.
Yes.
Please use the microphone, madam. Yes, 47.
Yes, Lordship.
Yes. Yes, what is your prayer?
Lordship, my senior is not well, so Lordship.
Who's your senior?
H. Gauhati, Lordship.
A. Chakraborty.
Yes, Lord.
For respond number 6.
Yes, Lordship.
My lord.
Okay, when do you want, madam?
Lordship, any date.
Friday?
So this Friday I will not be available. my lord.
Next Monday.
Well.
Okay. On a request made on behalf of Sri A. Chakraborty, learned counsel for the respond number 6. Matter is adjourned to be listed on 10th of 10/8. Sri B. Pathak, learned counsel for the petitioner is present.
My lord. The interim order of 20.
Is there an interim order?
My lord, 20 to 2026.
And the interim order passed earlier to continue till the next date of listing.
My lord, Item 6, 7 and 14, my lord. In this case, my lord, Mr. H.R.S. Chaudhary, my lord, he will appear, but he has to go for a medical checkup at Kolkata.
When do you want?
My lord, next week, any date, my lord.
Next week, okay.
My lord.
Other side informed?
My lord.
Please give the numbers again.
6, 7 and 14.
6, 7 and 14.
On a request made on behalf of Sri H.R.A. Chaudhary, London Senior Counsel, who is stated to be, who is stated to have gone for certain
Kolkata.
medical checkup,
Yes.
matters are adjourned. Matter is adjourned to be listed on,
Next week, my lord.
listed on Monday next, listed on 10th of August.
Oh, obvious.
Sri P.N. Goswami, Leonard AAG is present. Alag, huh? Is kar. 6, 7 and?
And 14.
6, 7 and 14. But tomorrow he has got these matters. Casually matters are fixed tomorrow.
Yes, my lord. Most probably we will take time, my lord, tomorrow. Obvious.
Then what about your colleague? He has fixed one matter
Yes.
tomorrow.
Yes, tomorrow, SS Ahmed, my lord.
Okay, let him be on the train then, and the entire train will be
Yes, my
adjourned.
lord, maybe we will take time, my lord, tomorrow.
10:35, my lord. He has sent a WhatsApp message. 10:35 today that they are taking time.
Very good. Good practice.
He has showed me the message also with all boldness.
Excellent.
10:35, man.
Something
Okay.
happened.
Obliged.
Obvious.
At least he has sent a message.
Too much.
You should appreciate.
Obliged.
Okay. You want to withdraw, Mr. Hawk?
Yes, ma'am.
Why?
My lord, petitioner was to withdraw, my lord, this case, my lord, because he does not want press now, my lord.
You have some other matter also.
Yes, yes, your person so many matters.
Huh?
Yes, so many matters. There.
Name is very familiar.
Yes, yes, my lord.
Is one matter fixed for judgment?
Yes, yes. Dwell, das Jogesh das JP.
Same person.
Same person, my lord. Contractor, reputed contractors, my lord.
Name appears to be very familiar.
He was the private
Okay.
respondent, I believe.
Yes.
In that matter, he was the private respondent, Lordship. The matter which your Lordship has will be giving judgment.
Okay. But this way or that way, he's in the litigation. Okay.
Yes, my lord.
Okay, Sri S. Hawk, learned counsel for the petitioner submits on instructions that submits that he has instructions to withdraw the writ petition. Also heard Sri M. here, learned counsel representing the Public Works Department. Para. Writ petition is accordingly dismissed on withdrawal.
Right.
Is there any interim order?
No, my lord.
Much good.
Obliged.
Let me close this contract.
Item 4 years
This order is substantially complied with.
complied with. Okay. Sri B.P. Bora, learned counsel for the petitioner, has submitted that the order has been substantiated. The order dated
18/6.
18/6/2026 passed in WPC number
161.
1619 of 2026 has been substantially complied with, and therefore he would not like to press this petition. Para? In view of the aforesaid submission, the petition is closed as not pressed.
Yes, Lord.
Yes, Mr. Sharma,
Yes, Lordship. This is.
have you done some research?
Yes, I've researched Lordship properly and I have prepared everything. The first
What is
one-
it?
The first one is a chronological and the second part is the notification, all the notifications are given. And in the chronological, Lordship, I have also put my questions that whether the award date is so and so passed by the labor code in chronological page, Lordship.
Yes.
Yes, Lordship. First, I have here mentioned the initiation of industrial dispute,
Yes.
21/5/2004, High Court has remanded. Then 21/11/2025, the industrial code was brought into. Then 8/12, industrial code removal difficulties was existed. So the director they continue adjudicating patent better under corresponding authorities. Then on 2/2/2006, two notifications I have enclosed.
Hmm.
So directed to continue the executing pending matter until corresponding authorities are constituted under the court.
Hmm.
On 2/2/2006, these two comes up, but even the old was in existence. 16/2/2026, Industrial Code Amendment Act was come up. Lordship.
Hmm.
Here, what happened, Lordship? Section 104A was inserted. The old act will continue. Then on 24/4/2006, our award was declared on 24th, and the rules was framed on 8/5/2026.
Hmm.
So the in next page, you know, kindly go to next page.
Yes.
Here I have left why this is not applicable and 553. So as per Lordship, I have prepared this two page gist of the thing.
Hmm.
So it says that the 55, the court cannot, because rules has not been framed. That's what the Lord says. The rules have not, so this is not implemented. So I have prepared this part, Lordship, the notification and so. And in respect of your notes,
But rules were framed. Rules were framed and
8/5/2026,
yes.
the rules become enforceable. 8/5, prior to that note.
Hmm.
This is, I have also given the notification, Lordship, side. You will find it that 8/5/2026, the Gazette also have submitted all that.
And in the meantime, the award has already been passed.
Yes, sir. One thing also, Lordship, also asked regarding the Madras Bar Association matter, that I have also prepared to that part. That is also not applicable, I have mentioned. This is.
So what is your prayer? What is your submission now?
My submission, Lordship, in chronological, I have mentioned the union may either, because as page number 3, you understand, I find it. Here, I have challenged this part. Now, in my case, repetition, I have challenged in the entire facts part, and the High Court order has not been complied. That I challenged before the order. So I did not touch this 55(3) new order. So Lordship, now it is raised regarding satisfaction of that part. So that's why I have submitted this representation, because it is to be transferred to educated in fresh under the old act. The award should be passed.
That means, amongst others, one of your main grounds would be application of the new code without any authority.
Yes, sir.
Without the same being enforceable, that was applied.
Yes, that
Rules were not framed.
Yes, sir.
Okay.
That-
That should have been the first point. That is what we had pointed. But nonetheless, it's good that you have done the research. Yes.
Yes, sir.
Heard Sri B. Sharma, Learned Counsel, for the petitioner who has put to challenge an award dated 24/4/2026, passed by the Learned Labour Court, Dibrugarh, in ID case number 5 of 2013. Full stop. By the said award, the dismissal of the respondent number 2, which was the subject matter of the reference, was declared to be illegal, and the petitioner has been directed to grant to reinstate the respondent number 2 with full back wages and all consequential pensionary benefits. Full stop. Para. The Learned Counsel, amongst others, has submitted that apart from the aspect that the Learned Labour Court had traversed beyond the jurisdiction, as the matter was earlier remanded by this court via a judgment and order dated 21/5/2024, the Learned Labour Court had also taken into consideration the Industrial Relations Code without even the rules being notified. Full stop. He has submitted, the Learned Counsel has submitted that on both the aspects, the impugned award would not be sustainable in law. Para. The matter would require deliberation. Full stop. Para. Issue rule returnable by 6 weeks. Call for the records. Para. Ms. Udas, Learned State Counsel, accepts notice on behalf of respondent number 1. Extra copies. 2 by speed post to TD. Steps within 2 working days. Sri Sharma, the Learned Counsel, pays for an interim order. Full stop. Upon considering the facts and circumstances and the grounds of challenge, comma, till the returnable date, comma, the impugned award dated 24/4/2026 is suspended. Full stop. The respondent number 2 would, however, be at liberty to file appropriate application under Section 17B of the Industrial Disputes Act 1947, if so advised. Full stop. List on 6 weeks. List on 1, 2, 3, 4, 5. List on 23rd of September. You make an additional affidavit, put this point on record.
Yes, that's it.
उसमें बीच में लिखे the learned counsel has additionally submitted, हाँ, जो ये है rules के वाला है, first तो हो गया, मैं हमको देख लीजिए, ठीक, okay.
So on that day, I will Madras Bar Association. I will reflect
Okay.
that part also.
Put it on on record by way of an additional. These grounds are not there in your.
Yes, yes. Yeah. Okay.
Please, kindly timing this matter. Timing.
What are these?
The preliminary work order was issued, my lord, way back in, my lord, March 2025. For my lord maintenance work of the, my lord, secretariat as well as the, my lord, minister.
Yes, that matter, yes.
And my lord, it has not been extended thereafter. I got the para-wise. And subsequently, my lord, this year we have already issued work orders, my lord, after tender. And it was only for a period of 6 months.
Okay.
So as such, no right, my lord, accrues on the petitioner, my lord, of basis of that. Whatever he has worked, that will be paid. Let me file the affidavit otherwise, ma'am.
You filed the affidavit?
Yes.
Well, is there any status quo order?
Status quo has been given, but my lord, status quo won't help the petitioner otherwise, because he has no right at all.
Okay, but you filed the affidavit.
I file my affidavit.
It's come for the stage of motion.
Yes, ma'am.
We can issue a short notice. Status quo will continue. Okay.
If status quo continues, my lord.
Heard Sri N.A. Mazhar Bhuiya, learned counsel for the petitioner. Full stop. The petitioner claims to have been issued certain preliminary work orders for maintenance of structures pertaining to ministers' bungalow and official bungalows in the secretariat.
Yes, ma'am.
Secretariat.
Secretariat as
Some
well as
ministerial
ministerial
quarters.
bungalows.
At dispute, including the secretariat. Full stop. The petitioner claims to have been allowed to continue, but the administrative approval for the said work had not come, and apprehending that there would be some other arrangement, the writ petitions have been filed. Full stop. This court, wide order dated 28/7/2026, had directed Sri B. Gogoi, learned AG, appearing for the Public Works Department, to obtain the instructions. Para. Sri Gogoi, the learned AG, has however submitted that the work entrusted to the petitioner was for a particular duration,
6 months. Sir.
which is 6 months. And upon completion of the same, the work has been entrusted to another person.
This year, yes, sir.
Another person. He submits that all these facts would be put on record by way of an affidavit. Para. Let notice be issued, returnable on. How soon can you file the affidavit?
Why not within 7 days I can file?
Within 7 days.
Yes, yes.
Returnable on today is 3rd. We can have it on 14th. You have enough time?
Yes, ma'am.
On 14th.
I pay for all.
Sri Gogoi, the learned AAG, accepts notice on behalf of all the respondents. Let extra copies be served upon him by tomorrow. Para. In the interest of justice, the order of status quo passed earlier shall continue till the next date of listing. Same order in all. Okay, you give the copies in all the cases.
On last occasions, I have furnished the extra copy.
If it is required, if it is required. Okay. If not served earlier. If not served earlier.
I didn't clear.
Yes.
We are before your lordship against the order of cancelling of tender. Earlier, the tender was given to us, and subsequently, without informing to us, they cancelled the tender.
Who is the respondent?
Joint Health Secretary.
Health, Mr. Bhuya?
I will inform the council who is here.
Who's there?
Is Deborah was here.
Ms. Deborah?
Yes, Lordship.
Please ask her to come.
Notice may be issued, Lordship.
So we have to issue in her presence, let her come.
Yes, sir.
Yes,
This is a challenge to an award passed by the industrial tribunal, my lord.
item number?
My lord, 15. My lord,
What is the award about, Mr.?
award is, my lord, about the reinstatement of the person with full back wages.
He was terminated.
He was not terminated, my lord. My primary case is that, my lord, we had abolished this particular post of general manager. And therefore, it was basically a severance of the service simpliciter, my lord. It was not a termination.
Retrenchment.
In a way, my lord. We had abolished.
If you abolish the retrenchment.
And then secondly, my lord, the post, my lord, was that of, my lord, operational manager. And my lord, therefore, it was a post of general manager, and we say it was not a post of a workman, my lord. And as far as workman is concerned, my lord, the law is settled that otherwise the burden is on the person to prove that he is, my lord, discharging a duty which is not, or which is coming within the purview of workman, my lord. This is very clear also in the decision of Lenin Kumar Ray, my lord, that the court has very clearly held recently, my lord. So these two aspects were, my lord, totally.
Did you take up this issue?
Yes,
that
my
he's
lord.
not a workman?
Yes, my lord.
He doesn't
that was
come
my
under
primary, my lord, objection.
He doesn't come under 2S of the definition.
That was our primary objection.
How was it answered?
My lord, the tribunal says that no, he is workman because simply because he is termed as a general manager, it cannot be, my lord, held that he will not be a workman. That is true, my lord. But then as to whether he has discharged the work as a workman, my lord.
But nonetheless, there's an award in his favor.
My lord.
Okay. Heard Sri B. Pathak, learned counsel for the petitioner who is aggrieved by an award dated 25/2/2026 passed by the Learned Industrial Tribunal Gauhati in ID case number 2 of 2025, whereby the discharge, was it discharge? How do you term? Discharge.
My lord, it will be a discharge.
Discharge of the respondent number
Sole
of the
respondent.
respondent was interfered with and interfered with a direction for reinstatement with full back wages and litigation cost. Full stop. Para, amongst others, comma, the learned counsel for the petitioner has submitted that the respondent did not fall within the meaning of workman, inverted, as defined under section 2 within bracket S of the Industrial Disputes Act 1947. It is also contended that the post was abolished and therefore it was not a case of termination in which an award direction for reinstatement could have been passed. Para. The matter would require deliberation. Para. Let rule be issued, returnable by 6 weeks. Call for the records. Let steps be taken for service of notice upon the sole respondent by speed post with AD. Steps within 2 days. Para. Sri Pathak, the learned counsel for the petitioner, prays for an interim order. Para. Considering the facts and circumstances, comma, till the returnable date, comma, the impugned award is suspended, full stop. The respondent would, however, be at liberty to file appropriate application under section 17B of the Industrial Disputes Act 1947, if so advised. Full stop. List on.
My lord, otherwise we have made a fair submission, my lord. His unpaid salary, because he did not come back, my lord, to submit his, my lord, report, my lord, at the time of my lord leaving service, his last 2 months' salary was not paid. This 1,20,000 we are ready to pay immediately, my lord. That may be observed.
उससे पहले क्या is for an interim order. उस interim order के बाद और अगले the learned counsel has submitted that the salaries for the last 2 months is ready to be paid by the petitioner. उसके बाद last minute considering that petitioner would be at liberty to file application 17B if so advised. सब एक सब एक ही रहेगा. List on 6 weeks we have said.
Hello.
1, 2, 3, 4, 5, 6. On 23rd of September.
23rd.
Lordship, the petitioner is a supply of liquid medical oxygen. He participated in a tender process along with respondent number 5 on 23/5/2025. Lordship, and respondent number 5 was allotted the work order. After he was allotted the work order, the petitioner checks various websites of several central organizations. It was found that this particular respondent number 5 was holiday listed by NBCC and subsidiary to it. Now the relevant clause Lordship would see the tender notices starts from page 16.
This aspect was not brought to the notice of the health authority.
Lordship, now apart from this notice, this tender process have been governed by the procurement.
This blacklisting was for what tenure?
From 2024 to 2026, 6 to 2024 to 7 to 2026. Now
this work order is allotted when?
Allotted on 5/7/2025, and the bid was floated on 23/5/2025.
And this allotment is for how many years?
3 years, Lordship.
3 years. So 1 more year is there.
Yes.
2 more years are there.
2 more years are there.
It started in 25.
25.
To 28 it is.
28.
Okay.
Lordship would see more than the tender clauses. Lordship would kindly see the rules for once.
Now we can ask Mr. Gogoi, yes. If he's blacklisted, you looked into this aspect?
We have already given a representation to the medical research department. Not only this tender.
And you have to notify this R6, R5 also.
R5.
He may have something else to say.
Yes, Lord.
Okay.
Yes, Lord.
Okay. Heard. Sri BP Bora, learned counsel for the petitioner. Full stop. As per the facts projected, pursuant to a notice inviting tender, wide e-mode on 23/5/2025, the petitioner along with the respondent number 5 had participated, in which the respondent number 5's offer was found to be suitable, and accordingly wide work order dated 5/7/2025, the work was allotted to him. Full stop.
Yes.
Him
But
or
it
it.
is for 2 years. I'm sorry. At page 16. 2 years. It is for 2 years.
Allotted to him or it differs. Respondent number 7. Allotted to it. Allotted to it, a person in the free. Allotted to it. The petitioner could subsequently, the petitioner had subsequently come to know that respondent number 5 was blacklisted by the NBCC for a period of 2 years. For 2 years, and during the consideration of the present tender, he was still the status of the respondent number 7 was still blacklisted. Full stop. The learned counsel has also submitted that this aspect has been brought to the notice of the official respondents, and as no action has been taken, the instant writ petition has been filed, para. Let notice be issued, returnable on. We'll have it on 2nd of September. 2nd September. Sri B. Google Learned AG.
1, 2, 4.
Assam accepts notice on behalf of Assam. 1, 2,
3, 4.
3,
and
4.
6.
What about 5?
5 my lord union.
No, 5 is also, 5 is union, correct. And 6. Union of India CGC. Mr. Decca. You accept on behalf of the CGC. Sri B. Decca and CGC accepts on behalf of son number 5. Let extra copies. Let steps be taken for service of notice upon the respondent number 7 and 8 by speed post tweet AD. Steps within 2 days.
Lordship, 7, we can take Dusty also as an extra mode.
If you want, you can. Service by Dusty upon the respondent number 7 as prayed for is allowed. Full stop. The Dusty is, however, required to be routed through the registry of this court, and the next date fixed is to be clearly reflected in the notice accompanying the Dusty. Full stop. Further, comma, prior to the next date, comma, the petitioner is required to file an affidavit in proof of such Dusty service.
Yes. Lordship, since it's a case of medical oxygen, Lordship, I am not praying for stay. Lordship, may issue notice on the.
No, let them come. If it's a matter of fact, we'll interfere.
Deeply.
Item 17.
May I please, your lord.
Yes.
We are agreed by my lord rent revision, arbitrary rent revision, my lord, from 11,520 to 1,44,000 per month, my lord. Notice was, my lord, that is at page 36, my lord. That has been issued. Earlier, my lord, that was open space was granted to the petitioner industry for starting the cement company, my lord. And that was rent was only for 4 paisa per square foot per month. Now that has been raised from 4 paisa to 50 paisa per month. That means ultimately, my lord, it becomes 1,44,000 per month.
But these are commercial relationship.
Commercial, but it is a village area, my lord.
No, not commercial area. We are not on commercial. It's a commercial transaction between you and maybe the government, but these are all.
But notice,
Should we enter?
even the notice was also not issued under, my lord,
Madam Bora,
Assam Public Premises Eviction and Authorized.
if you increase also, there should have been some
We are
prior
not-
discussion.
We are not on.
Where have
my
you
lord,
stated that you
we
were
are
not?
ready to consider, my lord.
Mr. Sharma, where have you stated that you were not put to notice?
We have stated, my lord.
Where?
Paragraph 6, my lord. Paragraph 9, my lord.
Paragraph 9.
9,
Let
my
us see.
lord. That is at page 14, my lord.
Please
Leave
read.
has been taken by the respondent authority unilaterally without issuing prior notice to the petitioner. Page 15, my lord. We have already submitted representation before the authority that has been processed, and the district general manager forwarded the same to the secretary.
Yes, how have you verified?
My lord,
How have you verified this statement?
I don't know.
How have you verified this statement of paragraph 9?
My, pardon.
These are essentially matters of knowledge and you are saying.
That is knowledge, man. That is knowledge.
Then how do you verify? If you don't verify properly, how do you
That is
take
knowledge.
into
Lordship
consideration?
will kindly consider. That is knowledge, madam. That is knowledge, madam. No notice has
You
been
don't give
issued.
importance to this affidavit page, which is the most sacrosanct
Yes,
page
I
in a writ
admit,
proceeding.
madam.
Except this, nothing is there.
I admit, madam. I admit.
There is no evidence, no cross-examination. Only this is the affidavit is the only thing.
Yes, I understand.
Also, Lordship, in lecture 6, my lord, there is no acknowledgement, neither the dates have been mentioned.
What is 6?
NHS.
That is the representation before the authority, my lord. That is the representation jointly submitted before the authority, my lord.
Have you actually done it, Mr. Sharma?
Yes, yes. That was already,
When did you do it?
that is on 21/12/2024, immediately
Where
after.
do you get the date?
My lord,
Where do you get the date?
that was, my lord, it
Where is
is
the date?
page 37, my lord, page 37, my lord.
No, in 42, annex, the representation.
That is, my lord, by post that has been sent, my lord.
Where
by
is the
post.
date? By post also will not put a date. Signature is okay. Signature is
And
okay.
lordship will
Office copy.
come to page 46, my lord.
Yes.
That is a letter, my lord, from the district general manager that letter has been forwarded to the additional director, CHD Industry and Commerce. My representation, my lord, that is Annexure 6 has been forwarded for consideration, my lord. Page
This is the
46.
forwarding of your letter.
Yes, my lord.
Okay, madam, there is a forwarding, he said. Okay, I heard Sri J. Sharma, learned counsel for the petitioner who is aggrieved by unilateral enhancement of monthly rent of the area which was allotted to him for establishing their industry at the Benibari Industrial Estate in the district of Baska.
Baska.
Full stop. It is submitted that the enhancement has been done from 0.04 paisa to 0.50 paisa per square feet per month without any prior notice or discussion. Full stop. Para. Let notice be issued. Returnable on 7th of August, 7th of September, Monday. Ms. B. Bora, no, first is Industries Commerce. Madam, Ms. Udas, Learning State Council, Assam, except for one.
That's not number.
One only, madam?
I'm for responding 2 and 3.
What about 4?
4, my lord, we are,
You can, Industries Department, about
Yes, yes.
Baksa. 1.
please, we don't, hear, my lord.
I'll take, my lord.
Okay, then, okay. 1 and 4, whereas Ms. B. Bora, Learned Standing Council BTC for 2 and 3, extra copies.
My lord.
Okay.
My lord, may I pray for interim order, my lord?
What interim
At
order?
least till then, my lord, at least till then, my lord. Till then, my lord. Lordship will kindly.
No interim order, no interim. Sri Sharma, prays for an interim order. Para. The same would be considered on the returnable date upon obtaining of instructions. Full stop. Para. Pendency shall not be a bar for the parties to sit across the table and resolve the matter.
My lord. Obliged.
18 is, my lord, somehow identical to item 15. Here, my lord, what had happened is that we had put the employee, who also we dispute is not a workman, because he was also, my lord, appointed as a operational manager. And that apart, my lord, he was only put on a show cause pending a domestic inquiry, which has been treated as a termination, my lord, and therefore reinstatement. He was never terminated, in fact. He did not cooperate in the domestic inquiry and he rushed to the labor court. And matter
The
was
domestic inquiry has not come to an end.
It has not come to an end. We could not, my lord, because he immediately rushed to the industrial tribunal. The tribunal came to a finding that he has been terminated, my lord, but then there is no order of termination, my lord. He was only suspended, my lord, pending domestic inquiry.
Now this there is some other matter also of this gentleman. Your second, what was the matter? Name appears to be very familiar. Petition number 2. Was there some other matter?
My lord, this, my lord, item 15 today.
No, not today. Earlier, one of
No.
these days.
No.
Uh, Let us see the award.
Would that, Friday, my lord, taken up some other blacklisting matter, my lord. But then this is not, the name is same, my lord, this is a private limited company. That was a firm, my lord. In the
But
name of alliance.
10%.
No, my lord. In a sense, my lord, that is a firm, but.
No, the person, Pradeep Changma is same.
My lord, his.
Yes, I remember this name.
Yes, my lord.
That height, Gauripur height.
Gauripur, my lord.
Let us see the award.
My lord, page 70, annexure 20. Award starts from page 71, my lord.
This was not by way of a section 10 reference.
No, my lord.
The individual reference, 2A reference. Okay. So what are the issues framed?
This is frame, my lord, would see at the page
75.
75, my lord.
Justified in terminating. You said that you are not even terminated.
There's no termination.
Okay.
There's no termination.
Okay.
There's only a domestic inquiry. And
Heard 3B Pathak, learned counsel for the petitioner who is aggrieved by an award dated 25/2/2026 passed by the Learned Industrial Tribunal Gauhati in ID case number 3 of 2025, full stop. By the impugned award, the sole respondent has been directed to be reinstated in service with full back wages and litigation cost. Full stop. Para. Amongst others, the learned counsel, others, Sri Pathak, the learned counsel, has submitted that the the sole respondent does not fall within the meaning of workman as defined under section 2 within bracket small s of the Industrial Disputes Act 1947. He has also submitted that no dispute as such had arisen as the matter was still at the stage of an inquiry which was initiated by issuance of a show cause notice. Full stop. It is submitted that there was no termination as such, and this aspect was failed to be appreciated by the learned tribunal. Full stop. Para. The matter would require deliberation. Para. Let rule be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondent by speed post with AD. Steps within 2 days. Para. Sri Pathak, the learned counsel, prays for an interim order. Para. Considering the discussions above made and the facts and circumstances, comma, till the returnable date, comma, the impugned award dated so and so stands suspended, full stop. The respondent, however, will be at liberty to approach this court by filing appropriate application under section 17B of the Act of 1947, if so advised. Let the returnable date be fixed on.
But she would fix the other one on 23rd.
23rd.
September. Of like.
Then 3 September.
Made please, your lordship. Petitioner before lordships challenging the 3 communications, my lord. My 1 3, my lord, impugned, my lord, 1 land, 2 land valuation certificate, my lord. My lord, then thirdly, my lord, is the acceptance of the tender of the respondent number 8, my lord. Very interestingly, my lord, please may kindly see the land valuation certificate.
Now, you tell us the fact, what is it about?
my lord.
You tell us the facts. What is it about?
My lord,
NIT.
there's a NIT.
NIT for?
NIT for, my lord, for tender of the IWTC, my lord. Regarding, my lord,
Which ferry?
settlement of Daukusi, Bhokodia, Rangasari, Pisara ferry service, my lord.
Daukuchi.
My lord. Pursuant to the NIT dated 31/12/2025.
Okay, you participated.
I participated. I am the second highest bidder, my lord. And
Second highest.
Yes, after submitting the tender, my lord, we have come to note from the online, my lord, they submitted the respondent number 8 submitted 2 land valuation certificate, my lord. And first land valuation certificate, my lord, they are mentioning the patta. He is not a pattadar, my lord. He is not match is the name, my lord.
Petitioner is R8 is not the pattadar.
Not the pattern. Number one. As second land valuation is concerned, my lord, the respondent authority, particularly the additional deputy commissioner, giving the commercial value of the particular land. But that commercial value, my lord, very interesting, my lord. Last date of submission of the tender on 21/2026. But they converted from the agricultural land to commercial land, my lord. Very interesting, your lordship, go to it, my lord. On, my lord, 23rd of March 2026, my lord. How additional deputy commissioner given the value, those who are on 3 lakhs per month per biga, and they given the 8 lakhs is a commercial land.
But it was converted on March 26.
March 2026.
Yes.
And submission of the tender, last date of submission of the tender on 21/20/01/2026 at 2 p.m.
2001.
Or 20-01/2026.
Okay. That means on the date of the
Submission of
submission,
the
it
tender.
was still an agriculture land.
This is agriculture, 3 lakhs, my lord. How they given the 8 lakhs? On the other hand, after submitting our complaint, the deputy commissioner inquired the commercial value is 7,50,000. He has given 8 lakhs. And at the time of submission tender, this is the, my lord.
Yes, madam.
Very interesting, my lord.
Already. What are your instructions?
May I read, my lord?
Yes, please.
Regarding land valuation.
Yes.
With, madam,
I'm
with
not-
reference to the, this is for me, I will file affidavit.
Mm.
With reference to the.
See, he has taken up 2 points.
Yes.
First, that so far as the first land value certificate is concerned, he is not the pattadar. And the second, there has been some conversion from agriculture to commercial, which is done after the tender date. So what are your instructions on that?
Second and third para is very relevant.
Yes, please.
Regarding land valuation certificate dated 26/12/2025, the allegation that the patta numbers and DAC numbers mentioned in the certificate do not match that respondent number 8 is not the recorded pattadar, it is misconceived. On verification with the corresponding Jamabandi, it is found that the entries in the certificate contain an inadvertent interchange of the patta number and DAC number. That is, the DAC number has been written in place of patta number and the patta number has been written in place of DAC number. This is merely a clerical error and does not affect the identity, ownership of the valuation of the land. And second, regarding land valuation certificate dated 14/7/2022, the allegation that the zonal value was wrongly calculated is also not tenable. Pursuant to departmental verification, the District Commissioner Kamrup Amingao conducted field verification and reported that the DACs covered by the zonal valuation certificate fall within Zone 1 of the village Daukuchi, as the land is situated within 500 meters of the main commercial hub of Nagarbera. Accordingly, the valuation adopted by the department was based on the competent authorities' field verification report and was rightly accepted by the tender committee. Financial merit. Respondent number 8 quoted rupees 90 lakhs census per year, which was higher than the petitioner quoted amount of rupees 85 lakhs per year. Since respondent number 8 was technically qualified and had submitted the highest valid bid, his bid was rightly accepted in the interest of maximizing government revenue. Well, my lord has in Ketanav's judgment had already held that government revenue is the prime most importance.
The government revenue is okay. That is one of the factors. But he has to be a valid bidder.
Yes, he is a valid bidder because we have accepted the report submitted by the competent authority. Here, competent authority is the deputy commissioner, district commissioner. Lordship may kindly ask them.
But if the conversion is done after the last date and the earlier value was 3 lakhs, it goes up to 8 lakhs. And there is, he said 7.58, we are not on 7.58, we are on the conversion part.
The lordship may direct them to take instruction, Deputy Commissioner.
Yes, Ms. Has this been made? The award has been made already?
No, my lord, it's just my lord accepted that tender only, my lord. Your lordship pays
Yet
50.
to issue the final.
But the R8's value is more than him. That is there, okay.
They may get instruction.
You get the instructions. We may not, had his value been more, would have definitely passed an interim order, but taking out everything, today we are not passing an interim order, but you have to take this. He's making a very specific and very serious allegation. First one, we may accept this, Dag, Go and Patta interchange. Second explanation, you have to put, and this you have to put on affidavit.
Pays 58.
Because we are accepting. the
Yes, yes, yes.
affidavit.
Yeah, you have to put on affidavit.
We'll also file affidavit.
Okay. Third, Sri N. Bora, learned counsel for the petitioner, who was the tenderer for the settlement of Daukuchi so-and-so ferry, which was notified on 31/12/2025. Full stop. Though the financial bid of the petitioner was found to be the second highest, the petitioner has made two specific allegations on the technical responsiveness of the bid of the respondent number 8. Full stop. Firstly, it is contended that in the first land valuation certificate, the name of there is a mismatch of the name of the respondent number 8 and the description of the land in question. Full stop. Secondly, it is contended that so far as the other land valuation certificate is concerned, the land was originally agricultural land, which was converted to commercial land after notification, after the present NIT, and therefore would not be relevant. Full stop. Para. Miss Bora, MD Bora, Learned Standing Council, IWT, has, however, submitted that written instructions have been received by her, as per which both the grounds do not appear to be tenable in law. Full stop. It is submitted that there was an inadvertent mistake in writing the patta number and the dag number, so far as the first land valuation certificate is concerned, and so far as the second land valuation certificate is concerned, the same was done after a field verification. Full stop. This court is of the opinion that the appropriate clarification has to come from the office of the district commissioner and the department. Full stop. Para. Let notice be issued returnable on, we'll have it on 28. Short date, but can you serve the private respondent?
By Dusty.
Dusty? Ms. Bora, the Learned Standing Council Transport Department accepts notice on behalf of respondent 1, 2, 3, 4, and 7. Whereas Sri S.R. Bora, Learned State Council, accepts for respondents 5 and 6 extra copies. Let step has been taken for service of notice upon the respondent number 8 by speed post with AD. Steps within 2 days. Para. On request, the respondent number 8 is permitted to be served by Dusty, which is to be routed through the registry of this court, and the notice accompanying the Dusty should clearly reflect the next date. Full stop. Prior to the next date, affidavit. Para. The prayer for interim order will be considered on the next date based on the instructions which are required to be placed before this court.
At least kept in abeyance, my lord, because of that, my lord.
No, we'll not do that.
My lord, is the illegality, my lord. Prima facie is the illegality, my lord. The prima facie illegality, there's a
Mr. Bora,
dead, my lord.
we'd have stated this had your offer been more.
My
On that consideration, not staying now. But if you find that it's not a valid thing, then we have to do it in accordance with law. Next date.
interim order considered next return.
Hmm?
That instruction kindly keep as a part of
Okay. The return instructions dated. Date, madam.
It's below
23/7/2026 is made, is kept with the records.
deeply applied.
Marvelous. One copy may also be served to me.
But affidavit, that affidavit I will serve definitely of that.
Much.
Item 12, thank
Item 12. Somebody was there? Mr. Laskar, Mr. Agarwal. What was it?
My lord, it is regarding cancellation of a tender process, my lord.
Council was here. Can you? You were not around. You know the council.
I don't know.
It should be there somewhere outside or after a while.
Yes, my lord.
Try to locate them.
Yes, my lord. 20.
Petitioner is a class 1 contractor, your lordship. He participated in a tender process for construction of quarters, residential quarters for judicial officers, your lordship.
This is in quarter for?
Judicial officers.
Where?
In the district of Chirang.
Okay.
Lordship, he participated in the tender process. Lordship may peruse page 263, annexure 5, your lordship.
What happened?
His technical bid was rejected on the ground that the bidder, lordship, at page 263, 1.8.
What is the ground?
On the ground that the bidder has not fulfilled the requirements of bidding documents as per clause 4.5 AG, qualification of the bid criteria of the bid documents. Now coming to the clause, your lordship, at page 50.
What is the present stage, Mr.
Work order
Mukherjee?
has not been issued, your lordship.
Somebody has been selected.
Financial bid has been opened, your lordship, and CS has been prepared.
No one has been selected. Why didn't you get the instructions? You can have this on Friday.
Yes, ma'am.
Friday. Till Friday, do not issue the work order.
Lordship, work orders, issuance of work order case has not come because since it involves more than 15 crore. Lordship, it has gone before the government for approval, and that will take some time.
Okay,
Lordship,
well, okay.
on Friday, Lordship.
Friday. Okay, then we can issue a short notice also, isn't it? Heard Sri B.J. Mukherjee, Learned Counsel, for the petitioner, footstop, para, as per the facts projected, the petitioner has claimed to be a class 1 contractor and had participated in a tender notice for construction of quarters of judicial officers in the district of Kokrajhar.
Chirang district.
In the district of Chirang. Full stop. However, his technical bid has been rejected on the ground of non-fulfillment of clause 4.5, capital A, within bracket small g. Full stop. The Learned Counsel has submitted that such rejection has been made unreasonably as the petitioner fulfills all the requisite qualification as provided in the NIT. Correct?
Lordship.
Full stop. Para. Sri B. Chaudhary, Learned Standing Counsel, Public Works Department has however submitted that only the comparative statement has been made and the work order as such is yet to be issued. Para. Be that as it may, let notice be issued. Returnable on. We'll have it on. Is there any private response? No private
Lordship,
respondent.
private respondents. Because we have also challenged the qualification of the private respondents, your lordship.
Okay. And the additionally, the Learned Counsel has also put to challenge the technical responsiveness of the bid of the private respondent numbers 5, 6, and 7.
5, 6,
Correct?
Lordship.
Ustar lakhe ekhine eiba. Ki kolo asto kine ki asile? Returnable on
Lordship sixth,
uh,
on sixth,
which 6th?
I'll have.
Private respondents
Lordship on 11 or 13.
of August.
Yes.
17th. They have to serve these private respondents. Okay. 17th. Sri B. Chaudhary, Learned Standing Council, PWD, accept notice on behalf of respondent 1, 2, 3, and 4. I think 4 BTC would BTC. 4 BTC, are you there? 1, 2, and 3. Whereas Ms. B. Bora, Learned Standing Council, BTC, accepts for respondent number 4. Extra copies. Let steps be taken for service of notice upon the respondent numbers 5, 6, and 7 by speed post PTAD. Steps within 2 days. Para. Additionally, comma, as requested, Dusty to Diba. Baki answer back. Okay, last to Diba. Considering the grounds of challenge, comma, it is provided that till the returnable date, comma, no final orders of allotment of the work is to be issued. Full stop. The aforesaid order would however be reconsidered on the returnable date on receipt of instructions. SC be reflected in the cause list. Dusty also, Mr. Mukherjee.
Supplementary discount.
Yes, 52. Implement. S. Roy, Laskar, Mr. Goswami. Where is Mr. Laskar? None appears for the applicant on call. Para, in the interest of justice, matter is adjourned to be listed on Friday. Next.
May I please, my lord, this particular writ petition is pertaining to non-payment of the part payment of the contractual amount. Now, my lord, in this particular case, I have been asked to bring an instruction whether the present petitioner is willing to continue with the work or not. My lord, now he is not willing to continue with the work. There is a reason behind it. Because, my lord, this particular contractual work has been allotted to him in the
Which
year.
was the order, Mr. Deka, that whether you'd be interested to?
My lord, perhaps the last order.
No, there
Or
is no
last to
such.
last order, my lord. Or I can pursue with this writ petition, my lord. That is not a problem.
Yes, your instructions, you have got instructions.
Lordship, we have already written, from the secretary to the additional chief engineer, my lord, we have written for Paramount, my lord.
When did you write?
We have received it on 3/2/26, my lord, although it is of May 2024, my lord. We have received this instruction on 3/2/26, my lord. Let's see.
So you filed the affidavit. Let us decide the matter.
Lordship, Paramount's instructions are awaiting.
You get the instructions, matter is pending since 24.
My lord, this work has been allotted by the GAD department, my lord. So,
Mr. A. Fukan? Where is Mr. A. Fukan? Is he there or not, Mr. Aruna Fukan?
On the last occasion, my lord, he has taken death due to some illness. But I do not know whether he has recovered or not.
On his behalf, a request was made.
Deeply obliged.
You're correct on the last occasion.
Yes.
We can have this on Wednesday.
Yes,
Reply
sir.
prior to inform him, okay? While Sri B. Deka, learned counsel to the petitioner, and Ms. B. Bora, learned standing counsel BTC are present, comma. Sri A. Fukan, learned standing counsel GAD is not present while when the matter is called upon, para. In the interest of justice, matter is adjourned to be listed on Wednesday.
My lord, not Wednesday. Let it be on Thursday or Friday.
On Friday.
Friday.
Friday. Okay. Friday record. This court has been informed that due to some health issues, Sri Fukan is not present in the court today.
Deeply obliged.
Friday. Let us have it on Monday next. We give him some time. Okay.
Let it be on
Dr.
Monday.
Talukdar, Monday. Get some more time. Monday will be 10th. Yes. 28, who's 28? TJ Mohanta. Yes.
So see, in this case, on last occasion, the department was sought instruction whether they will, what is the status of refund of the petitioner's initial bid deposit. But
What about who was the who is for excise?
Dixit, so let's see, let the matter be after some time, I will inform them.
But names are shown or not?
No, phone receive,
Where is the excise department? Please try to help them.
In this case, I am appearing for respondent of have newly included that affidavit in opposition is filed today, after some time.
You have filed.
We are in the process of filing.
Okay, let him file then.
Lord.
Okay.
So far as the respondent numbers 1, 2, and 3 are concerned, I have received the affidavit in opposition.
Okay. Heard Sri Y. Kothari, learned counsel for the petitioner. Full stop. Also heard, you for whom?
Respondent number 4, Madam.
Who is for excise? You have also filed affidavit.
I filed affidavit and rejoinder has also been.
Okay. While affidavits have been exchanged with the private respondent and respondent number 4, comma, the newly implemented respondent number 5, represented by Sri P.P. Dutta, has informed that the affidavit in opposition by his client would be filed during the course of the day. Full stop, para. Let such affidavit be filed and the matter be listed along with the affidavit.
Yes.
On Friday.
Lordship, just one more aspect. So far as my personal belongings were concerned.
Let us see. On Friday, we'll see that aspect.
All right.
You serve him a copy in advance.
Deeply.
Where is excise? Last case also excise not there. Yes, Mr. Borthakur, excise is missing. Why? 2 matters, both the matters, this and yesterday. Last matter also.
Be taken up at 2, my lord.
2, if we finish the matters, we'll not sit at 2 o'clock. You come before that.
After, can it be taken?
After a while, Mr. Who's there? Mr. Otto is there.
28 on the number.
Eto আমি exercise নাই বুলি কোৱা নাই, একো লিখিব নালাগে second. ঠিক আছে. Yes. Next.
I think 31 is fixed on Friday.
Your matter, yes, his matter is Friday.
Friday.
Mr. Dutta, the other matter is Friday, where your affidavit will come.
May I please, my lord, this case relates to the non-renewal of armed license, my lord. I have purchased the armed license by following a due procedure of law, my lord. While I have
applied for the renewal, my lord, that has not been granted to me, my lord. I have approached to the authority by filing a representation also, my lord. And since, my lord, license once given and I have purchased the gun, my lord, that cannot be, my lord, withheld. To that effect, my lord, our different high courts, I have obtained the copy from, my lord.
What do you do?
I am a, my lord, politician plus businessman, my lord. I was the last candidate of Congress from Hajo, my lord, plus now also, my lord, I'm the active member of the Congress party, my lord. And I'm having,
There have been instances earlier.
yes. They
Oh.
have cut my head also, my lord. I have an.
Cut your head.
Yes.
You're still alive.
My lord, lordship will see, my lord, the photo.
Head is cut and you're still alive without a
My
head.
lord, I got a severe injury, my lord.
Okay, injury,
Severe injury.
not cut.
It is a cut mark is there, my lord. I have an next photograph also.
Okay.
To that effect, I have lost an affair also, my lord. And now my life is under threat, my lord. Lordship will see page 40 and 41, my lord.
Yes, what do you say, Mr. Barua?
Police authority has strongly recommended against the renewal of the license.
Okay.
Because some criminal cases are pending, lordship.
Oh.
Because page 103 of our affidavit.
That has been
Communication of
clarified
the-
by other.
103.
103 of our affidavit, Annexure B.
Yes.
The communication from the.
No, no. তো আমি দিয়া দেবো ভাই।
They have mentioned the cases and last they have strongly against the recommendation.
My lord, in the most of the cases, I got the acquittal, my lord. I have annexed, and they said, my lord, a vague statement, my lord, having case. To that effect, my lord, having to Gusai dia na. Orders, আরোটার মধ্যে দিয়ে একটু কি করলো সেনেগাল অফ দ্য
In one case, still investigation is going on. 506/2025 case number.
Now, where is your affidavit? Page 10?
In my affidavit. In paragraph 4 of our affidavit.
Who has filed? Mrinal Bora.
Bhupen Bora.
Not Bhupen Bora, Mrinal Bora. Mrinal Bora is the son of Bhupen Bora.
Yes.
That affidavit.
Minal Bora.
90 page 9, that is page 97.
Yes, page 98,
90.
paragraph 4, we have taken lordship because the matter is under scrutiny and the license has not been
Hajo under section has filed, see.
following a regency
Enforcement
for the police verification report.
Otherwise, my lord, the
99 lordship.
power does not empower the police authority.
So it's a subjective satisfaction, Mr. Borbia.
Lordship
There are
will-
police cases against you.
Lordship, there is a, my lord, there is a not correct, my lord. I have filed my additional
This
affidavit.
is the proceeding,
Most of
lordship.
the cases, my lord, most of the cases, my lord, it has been turned to be final report, my lord. I have an additional.
Most of the cases, will it do all the cases? We need all the cases.
Only one
If
case
there
is
are criminal antecedents, you have criminal antecedents.
My
How
lord,
do we,
to that effect, my lord.
how do you
it has
expect
been-
this court to
It
pass
has
an
been
order?
decided by another bench of High Court, my lord. Lordship, can we have a look, the Andhra Pradesh High Court, my lord. Even
No, Andhra Pradesh High Court.
if
We are on the subjective satisfaction. It's not a question of precedence of
My
some
lord,
high courts.
Even, my lord.
If they are on the, having the satisfaction, opinion,
My
that
lord, they cannot give two types of opinion, my lord. While giving license, they said, my lord, I have a life threat. Now they said they
the
cannot.
circumstances cannot change.
It can be changed. It can be changed, my lord. It can be
These are
changed.
all subjective satisfaction.
Lordship, before that, my lord.
And we will not only not go into the adequacy of the reasons. Reasons have been cited and
My
that by
lord,
the
I have
authorities,
filed my
including giving
additional-
objective reasons. Police cases are there. We are
My
against
lord, police case
citizens
does
having a
not
license.
debar me, my lord. Does not debar me.
It's not a fundamental right to have a license of an arm.
My lord, what
Is it
will
a fundamental
happen to my
right?
arm, my lord, now?
You'll have to surrender your
I have
arm.
purchased it 2 lakhs.
You have
3
to
lakh.
surrender your arm. Is it America?
No, my lord.
That
it
you
will
buy
be-
an arm
no,
and
no,
you
my
have
lord,
it.
It will be the
It
prejudice
is
to
not.
me.
Law and order is there.
Because, my lord, on the last
Sorry.
occasion, my lord, while
That is
granting.
not a argument at all. That's why I have what will happen to my arm.
No, my lord, I'm not saying about that, my lord. The
It's not a
police
fundamental right.
authority, my
Sorry.
lord, does not empower, my lord, to my recommendation, my lord. It is the authority as per section 14 of the act, my lord says.
This is not filed by the police. This is filed by the additional deputy commissioner.
My lord, basing on the report of the police, my lord.
Obviously, some reports should be taken into consideration. Sorry. Heard Sri J.I. Borbhia, learned counsel for the petitioner. Also heard Sri S.R. Barua, learned state counsel. Full stop. Para. Considering the facts and circumstances and also the fact that pleadings have been exchanged, comma, this writ petition is taken up for disposal at the admission stage. Full stop. Para. Please have your seat. As per the facts projected, comma, the petitioner was issued an arm license bearing number so and so on 12/6/2024, pursuant to which he is possessing an arm. What is the arm? Pistol.
My lord.
Pistol. Full stop. The petitioner had submitted an application on 22/5/2025 for renewal of the same. Full stop. However, even after elapse of more than 6 months, the same was not done, and accordingly, the petitioner had submitted a reminder. Full stop. The petitioner was, however, served with a communication dated 17/11/2025, whereby certain details of the case status were sought for. Full stop. Para. The learned counsel for the petitioner has submitted that the arm was purchased by the petitioner on the basis of the license issued to him on 12/6/2024, and there being no discernible reasons not to renew the same, the grave prejudice would be suffered to the petitioner. Full stop. It is also projected that the petitioner is an active politician and also a businessman, and there have been physical attack on him, leading to registration of police case. Full stop. He has submitted that there are bona fide reasons requiring the petitioner to carry an arm for his own safety. Full stop. On the other hand, Sri Barua, the learned state counsel, by drawing the attention of this court to the affidavit in opposition filed on 19/5/2026, has submitted that there are a number of police cases against the petitioner, which involves use of the arm. Full stop.
It is
It is submitted that under those facts and circumstances, renewal of the license would not be in the interest of justice and public safety. Para. Sri Porvia, the learned counsel for the petitioner, has, however, submitted that rejoinder affidavit has been filed on 12/6/2026, and he has also emphasized the fact that in most of the cases, final report has been filed, and therefore there is no substance in the defense adopted by the respondent in this case. Full stop. Para. The rival submissions have been duly considered. Full para. It is not in dispute. No. It is a settled position of law that there cannot be any fundamental right to carry an arm. Full stop. This court is of the view that unless a citizen makes out a case that there are clear threat perception which can be supported by objective materials, and further that the state has failed to give the minimum, with the necessary safeguard, comma, seeking an arms license or possessing an arms cannot be held to be justified. Full stop. Para. In the instant case, comma, in the affidavit filed by the respondent number 2, comma, details of at least 3 police cases have been stated in which the petitioner is involved. Full stop. For ready reference, the averments made in paragraph 4 of the affidavit are extracted herein below. Full stop. Para. In the rejoinder affidavit, comma, the petitioner has sought to give certain explanation, including the fact that most of the cases has culminated in filing of final report.
Final report or acquittal.
Final report, and in few cases, final report / acquittal. Para. While the aforesaid facts, while the aforesaid projection may be correct, comma, this court is of the considered opinion that issue of arm license not being within issue of the renewal of arm license not coming within the fundamental rights, comma, the subjective satisfaction reached by the renewal authorities, which are also based on certain objective materials, cannot be matters of interference. Full stop. This court is of the opinion that unless such refusal is blatantly in violation of certain rules, comma, this court would be loath in interfering with matters of this nature. Full stop. This writ petition is accordingly dismissed. Okay, 5 minutes, we'll take a break. 3.
My lord, in this case, my lord, I filed reply.
You have filed affidavit?
They have filed affidavit, my lord. I
With
filed-
PHE or what? Excise?
No, my lord.
APDCL?
APDCL.
Okay. Sri R.S. Chauhan, learned counsel for the petitioners, praise for, and is granted 3 weeks' time
Yes.
to file rejoinder affidavit against the affidavit in opposition filed by the respondent number 5. Para. Matter is accordingly adjourned to be listed on 24th of August. Sri Sharma, the APDC, learned counsel, is present for the APDC. You're and here, Art Aludar, huh? How about Art Aludar? Art Aludar and V.S. Sharma.
Please, your lordship. Lordship, in this matter, my lord, we are going to file our affidavit today, my lord, during the course of the day.
There's an interim order.
My lord.
Okay. Part 3, UK Das, learned counsel for the petitioner. Para. 3, Miss B. Bora, learned standing counsel, BTC, has submitted that the affidavit in opposition would be filed during the course of the day. Para. Let such affidavit be filed and the matter be listed along with the affidavit on Friday?
Not Friday, my lord. Monday.
Monday. If you want time, we'll give you time for rejoinder.
My lord.
Okay. 10th. Interim order passed earlier to continue till the next date of listing. Item number P. Sharma.
My lords will take some time to file an affidavit in this matter.
Okay. On the prayer of Sri S. Sharma, learned counsel representing the Forest Department, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Full stop. List on 26th of August.
Pleasure.
Item 28.
Yes.
May I place your lordship? Lordship, the opposite party has filed already.
PNRD. Okay. Okay. Ms. P. Thapa, learned counsel representing Sri S. Datta for the PNRD, submits that instructions have been received and the affidavit would be filed. What about madam? Ms. Udas representing the respondent number 5. Huh? Yes. Who? Representing the state respondent has informed that our respondent number 5 has already filed the affidavit in opposition. Para? Well, how much time, madam?
2 weeks.
On request, matter is adjourned to be listed on 24th of August to enable filing of affidavit in opposition. Yes.
Item 12.
Yes, what is this?
The tender was cancelled without informing me. Earlier, I was allotted the tender, and without informing me, the tender was cancelled. The order, the tender cancellation order is an.
The work order was issued to you.
The work order.
Work order is not issued.
The minutes adjudging him along with one another as L1 minor.
Thereafter, cancel.
Yes, cancel because my lord, there were certain allegations of anomalies, my lord, and thereafter everything has been duly considered, my lord, and by the NSM authority as well as the Director of Health Services Authority, and subsequently it was directed to cancel the NIT. Otherwise, also, my lord, there was only a minute adjudging the petitioner along with one another at L1, which doesn't give any vested right to him.
No, that is okay, but there has to be some discernible reasons
Yes, my lord.
for which you can go for a fresh tender.
Yes, my lord. That has been stated in the, it is the preliminary instruction I have received, wherein, my lord, it has been specifically discussed what are the anomalies.
So what is the present step you are taking?
My lord, as per this letter, my lord, a fresh NIT will be issued, my lord. Fresh NIT will be issued, my lord. It is for supply of dietary articles, my lord.
Where?
In the government hospitals, my lord.
But what have you assigned the reasons for cancelling?
My lord. Paragraph 4, my lord. This further observed that the initial tender number so and so dated 17/3/2025 was floated with proper guidelines and additional terms and conditions. Subsequently, the said tender was cancelled on the grounds that it had been compromised. Thereafter, modifications were made to the original guideline and a fresh tender 5 so and so dated 25/7/2025 was floated with altered conditions. Because those altered conditions, my lord, that was not allowed, my lord. Because the original tender, my lord, that was issued otherwise with the proper guidelines, my lord.
Okay. You file your affidavit,
Yes,
but
my lord.
the steps which you are proposing to take would be subject to the outcome of this. You have to examine his case.
Yes, ma'am.
What is your name?
D.K. Agarwala.
Third Sri D.K. Agarwal, learned counsel for the petitioner. Full stop. As per the facts projected, comma, pursuant to tender notice comma, for a tender notice relating to healthcare, kitchen and dietary service inverted comma silaba, comma, the petitioner had participated his bid, which was found to be suitable, and petitioner along with another were held to be the L1 bidders, full stop. However, comma, wide the order dated 10/6/2026.
I am the L1, my lord. If,
He says,
I am the L1. There's only one person.
The two L1, my lord, but being a local vendor, my lord, he was selected.
and we'll say, don't say L1 नहीं कहो, आगे की बोलिए question. And was adjudged as L1, full stop. The grievance of the petitioner is, however, with an order dated 10/6/2026, whereby the tender was cancelled with a decision to go for a new tender, full stop. It is submitted that such cancellation has been done in a most unreasonable manner. Para 3. DP Bora, Learned Standing Council Health Department has, however, submitted that he has obtained written instructions, including the communication. No, he has obtained instructions, written instructions, including a communication dated 30/4/2026, issued by the Director of Health Services, as per which, comma, in the earlier process, comma, there were some anomalies which had come to the knowledge of the respondent authorities. Para. Considering the above, comma, let notice be issued, returnable on 28/8/2026. 3. Bora, the Learned Standing Council Health Department accepts notice on behalf of all the respondents. Let extra copies be served. Para. 3. Agarwal, the Learned Council prays for an interim order. Para. Considering the nature of the work, comma, while this court is not inclined to pass any blanket interim order, comma, it is provided that all actions taken for a fresh tender would be subject to orders to be passed in this petition.
So grateful.
And I have received the instructions, the petitioner, after his application for an alternative site. Now, my lord, some objections have been received from the local residents. So those objections will be disposed of by the district commissioner. We have, from the excise department, he has been asked to dispose of the objections as soon as possible. Then, my lord, a final decision will be taken, my lord.
You are also agreeable for refund, that
Yes,
case.
Lordship, because due to apathy on the part of the department.
If you are not in a fair enough position not to allot, refund the amount.
For that specific instruction was sought, Lordship, by this honorable court on last 2 orders, Lordship.
But since my lord petitioner has already participated in this alternate site.
No, it was prior to that, Lordship. That I participated.
He is not interested in the alternate site.
I participated for alternative site prior to that passing of this order.
Kotaku need to have specific instructions on the steps taken for his refund. He is not interested to run.
Even Lordship, ADC, it was lying for another 2 weeks, Lordship. It was without any. ADC, the jurisdictional in charge excise officer, Lordship. In one hand, they are sleeping over the matter, Lordship, delaying that matter, and also not refund the amount, Lordship. Even that specific instruction was not.
Borthakur, we are not very happy with your dilly-dallying tactic. Take a decision and refund the amount. He is not interested. Spending since 2025 for no reasons. He is not paying for a allotment of the shop. He is not interested. You are not being able to give the shop, refund the money.
It is only in final stage, my lord.
Heard Sri P.P. Datta, Learned Counsel for the petitioner. Para. 3. I. Borthakur, Learned Counsel, representing the Excise Department, has prayed for some more time for resolution of the matter, para, considering that this court had granted time on a number of previous occasions, comma, as a final opportunity, comma, 2 weeks' time is granted to the respondent authorities to resolve the matter. Post of list on 19th of August, on which date updated status is required to be placed before this court. Ms. Udas, Learned State Council is present.
Obliged.
Sri R. Talu, the Learned State Council, and Ms. U. Das, Learned Council for the respondents 6, 7, and 8 are present.
Obliged.
কি matter? Matter ব্যাপারে কোন other side কোন? Udas আছে না really? Which matter somebody is appearing in person? Madam, you are there in 53. Yes. Yes.
Actually, earlier advocate was involved in
No
this
problem,
case.
no
Now,
problem.
sir, I need some time for next date for submission against their affidavit.
The petitioner has appeared in person.
Yes, sir.
Full stop. Also heard Ms. A. Bora, Learned Standing Council, NHM. Full stop. The learned advocates had clarified that the brief has been taken back by the petitioner who would be appearing by himself. Full stop, para. The petitioner in person has prayed for some accommodation. Para. On request list on which date? Tell us.
Yes, Assam, sir.
Which date? Which date? Next date?
Sir, as per your.
No, but whenever date you.
Next month, sir.
Hmm?
Next month.
Next month?
Yes, sir.
Tell us a date. Whichever date you want. We can have it on 2nd of September. Is it okay?
Okay, sir. No problem.
2nd of September.
Thank you, sir.
May I please, Your Worship? Sir, we had prayed for an LOI, letter of intent, my lord, with regard to my lord opening of a nursing college, my lord. The respondents have filed an affidavit. They've raised two issues, my lord, page 58.
Yes.
The land is in the name of my lord, the chairman, that is the petition number 2, that is Mr. Muzammil Borbia. And my lord, that the parent hospitals, my lord, strength, my lord, bed strength, etc., has not been certified by the competent authority. That's the my lord, position they've taken, my lord. We have, my lord, submitted a reply, my lord, saying that, my lord, that Muzammil Borbia, my lord, is the chairman of the, my lord, trust, my lord. And he is already, my lord,
You have filed rejoinder?
Rejoinder filed, my lord.
When did you file?
My lord, on Saturday, my lord, just mentioned as mid-morning, my lord.
Oh, yes, it has come.
Yes, my lord. In our reply, my lord, in page 2, my lord, sorry, page 61, internal page 2.
Have you been served with this rejoinder, Mr. Bora?
Yes, my lord.
We can have this for admission hearing.
My lord, my lord.
If you want, we can have day after tomorrow also.
Day after tomorrow, some difficulties, my lord. Can we
Thursday?
Can be Friday, my lord?
Thursday or Friday?
Friday.
Mr. Bora, if you are agreeable.
Yes,
Okay. The rejoinder affidavit filed by the petitioner has been placed on record. Para. Sri M. Dutta, Learned Senior Counsel for the petitioners, as well as Sri D.P. Bora, Learned Standing Counsel, Health Department, have jointly submitted that the matter can be taken up for final disposal at the admission stage. List for admission hearing, 26 matter. We can have it on Tuesday next, on the 11th of
11th.
August. 42, yes. Mr. Chaudhary.
Affidavit has not been filed, my lord.
We are awaiting the instructions.
Hmm. Yes, you have got the instructions.
Waiting the
Okay. Notice was issued on 26/6/2026. Full stop. Ms. P. Thapa, learned counsel representing the PNRD department, has prayed for time to enable receipt of instructions / filing of affidavit in opposition para. Matter is accordingly adjourned to be listed on 28/8 to enable filing of affidavit in opposition.
Obliged. Your lordship. Lordship, matter may be taken after some time, lordship.
Why sometime?
Lordship, my senior is in court number.
What is the matter? You file affidavit, madam?
The settlement, lordship, the settlement period is already over, so we are processing for the e-tender process. So lordship.
Settlement period is over.
Lordship, no.
No, that was the case.
The new settlement, lordship.
My settlement period has been expired on 30/6/2026.
Yes.
Thereafter, lordship, no.
They are taking steps for settlement by e-mode. What is there to be decided here? You participate in the new, under the new method. You have, after some time, but in the first time itself, after a while, call your senior.
44.
May I please, your lordship?
Yes, Mr. Laskar.
My lordship, regarding my lordship, the department has seized some products, my lordship, perishable products.
Notice was issued. Yes,
Yeah.
Mr. Sharma.
Lords, we have just received the interim order of the authorized officer. My lords, we kindly give us a week's time to go through it and file a response.
Okay.
My lordship.
Grant some time.
Lords, on a preliminary.
Interim prayer may be considered, my lordship, because it's a perishable product and there is no dispute regarding the product, my lordship.
You have the instructions. So day after tomorrow or Friday we'll have it. Okay, Friday. Heard Sri S.B. Laskar, learned counsel for the petitioner para. Pursuant to the notice issued by this court on 17/7/2026, Sri S. Sharma, learned counsel representing the Forest Department, has submitted that certain instructions have been received. Puts the he prays for
An interim order from the authorized officer.
instruction including an interim order by the authorized officer para. He however prays for a little accommodation para. In the interest of justice, matter is adjourned to be taken up on Friday. Come up with a written printed format.
Highly obliged, my lord.
Friday, 14.
54.
Yes, sir. 14. 14, no, actually, 14 is like 7th, 7th, not 14, 7th. Yes. Item number?
54, lordship.
Yes, office note.
We file our reply, lordship.
Hmm?
We file our reply, lordship. Against the affidavit in opposition.
In a hearing, whenever you say. And matter can be perhaps be sorted out now.
Yes, sir.
After
Already. I have already.
Thursday, we'll try.
My lord.
Inform Mr. Gogoi.
Yes.
D Gogoi means Dixit Gogoi.
Dixit Gogoi. Then
While Sri Ghosh SK Ghosh, learned counsel for the petitioner, as well as Ms. Udas, learned state counsel, are present, comma. The learned counsel for the AEGCL is not present when the matter has been called upon. Para. In the interest of justice, matter is adjourned to be listed on when, Wednesday or Thursday?
Friday. Oh,
Right?
Thursday.
For admission.
Madam,
Please inform.
Island.
Wait, please, Lord. Lord, it's a case of blacklisting, my lord, by an authority not competent. Plain and simple. And my lord, if your lordship would kindly come to page number 87, my lord. (8.1) works with sanction cost of civil works up to 5 crore. State PWD shall evaluate the bids and finalize tender as per ministry's extent guidelines. So basically, my lord, they are to do as per the ministry's guideline. Then my lord will kindly come to page number 96. It's a part of the OM issued by standard operating procedure issued by MORF, my lord. Let's
Page
come to page 96, serial number 5.
96.
Yes. Was the bottom of the page. This is of course on the merits of the case. Fails to complete rectification as per time given in non-conformity report, etc., etc. Then on the right hand side, declaring the contractor concessionaire as non-performer till rectification is completed. So it in any case, even in that case also, my lord, it is only for a limited period. Then eventually at page 105. So these are the procedural safeguards, my lord, which has to be construed very strictly. Para 5.
105.
105 para 5, my lord. Before deciding a contractor concessionaire as non-performer or debarring penalizing it, the concerned authority shall issue a notice to the contractor by giving 15 days time to furnish its written reply and allowing personal hearing. So not only notice, my lord, personal hearing is also required to be given. Here the notice was just 7 days. No? 7 days notice was given as against requirement of 15. Personal hearing. Then, my lord, para 6.
Personal hearing given.
Given. Para 6. The competent authority for approval of panel action as above will be Director General in respect of NH work being implemented to the state PWD. So, my lord, the competent authority is Director General and the impugn order has been passed at page 83 by the Chief Engineer, my lord. It's page 83 and lordship can see at page 84 it is passed by the Chief Engineer PWD. So since we are concerned with the decision making process, my lord,
yes,
my humble submission is number 1, procedural safeguards provided in the SOP has not been extended. Number 2,
yes, Mr. Gogoi.
an authority other than the competent authority had passed the order and they filed an affidavit where they have not touched this point. So the statement remains unrebutted.
Time is concerned, it was given personal hearing given.
Oh, you are on the aspect of authority.
Well,
Has it been done by the appropriate authority?
possible, see, my lord, it has been issued by the chief engineer himself.
No, the order has to be done by the Director General.
No. What it says, my lord, para
Yes.
6, my lord.
Yes.
The competent authority for approval
Yes.
Where is the
of penal action as above will be the Director General in respect of
Okay, maybe the issuing authority is Chief Engineer. Has it been approved by the DG?
on that point.
No, if it is, Mr. Chaudhary, we may not be very strict.
I think I was not very clear, Milord.
We may not be very strict on who was issued.
No,
We need
even-
the
even
approval.
Approval is also not.
No, no, he has, Mr. Gogoi has very fairly said that part he has not, he doesn't have the instruction. Maybe the communicating authority, maybe the chief engineer, because it's under the chief engineer, but it has to be approved.
True. Milord, will kindly have a look at page 105, 1 second, Milord.
Yes.
Para 4, Milord.
Yes.
Chief Engineer, Regional Office, Headquarter, Mort, Chief General Manager, NHAI, Executive Director, NHIDCL, Chief Engineer, Border Road Organization shall be the competent authority for certifying report submitted by nominated officer regarding completion of the rectification. Milord, my humble submission is at page 85, it is clearly stated, Milord, when it is 5 crore and above, then it has to be as per the extent rules of the MOT. And these are the MOT rules. In any case, Milord, assuming for argument's sake that chief engineer can communicate the order, where is the approval of the where is the approval of DG? Yes, serial number 6, page 105. 9. Then I will.
But only one thing, my lord, he was, my lord, put to notice to rectify certain, my lord, portion
Up
of the
to
rules.
87, can we have 87 again?
Yes, Milord.
8.1. Works with sanction cost of civil works up to 5 crore.
Yes.
State people shall evaluate the bids and finalize tender as per ministry extant guidelines. And works with sanction more than would be devaluation committee competition. Then who does that?
State PWD, Milord. Up to 5 crore, it is state PWD.
As per ministry's extant
Yes.
guidelines. Yours is up to 5 crores.
Yes.
Then the guidelines will have to be followed. But it will
By the chief engineer.
By the chief engineer. So, but for panel action, approval is required.
Only that part,
Okay.
approval part. I've checked it, my lord, I've inquired also. Probably, my lord, that is not there, but my lord, it is the irregular, that liberty may be given, my lord, even till today, the rectification is not been.
That's a different aspect, Milord. We are challenging the decision-making process.
Heard. No. Don't say heard. Please have your seat, Mr. Prabhu.
Milord, there is one more development, Milord. But we have filed an additional affidavit we have brought on record, Milord, at page 138.
138.
Yes.
Yes.
Filed in.
Part of the record.
Milord, consequentially, this action has also been taken.
139 perhaps.
Yes, 139.
We did not put 138 by mistake.
Okay. 139, yes.
No,
The
137
index we have shown as index.
137 is the last printed
Yes.
page, thereafter 138 is missing. Doesn't matter. At times it happens.
This is to inform all concerned.
The first letter, 1st August letter.
Yes, Milord.
1/8.
This is to inform all concerned that since contractor, Rana Construction, etc., so and so has performed unsatisfactory work as per the test result received from Assam Engineering College white letter dated and failed to rectify the same as instructed by the office letter dated so and so, as informed by the executive engineer, Sri Bhumi, NH division white letter dated, as replied to this office letter dated so and so. Hence, the registration of Rana Construction Engineer being registration number is hereby suspended on the ground of unsatisfactory work. So this is a very harsh action, Milord. Prior to this, there was no notice also.
Subsequent action.
But
because in continuation of the same notice.
Route is that. Now you may be right in submitting the technical this needs to be
Technically,
put.
correct.
But route, if you touch the route, this will also go.
In any case, when an illegality is brought to your lordship's notice, lordships can always take care of it.
Consequential action or
Yes.
not. Okay.
But the liberty may be given to us.
Yes. You can definitely follow the guidelines, but not like this.
Yeah.
The instant petition under Article 226 of the Constitution of India has been filed seeking the following relief. Full stop relief. As per the facts projected, comma, 3 works under the Karimganj and its division were issued to the petitioner pursuant to a tender process which he claims to have concluded, and certificates towards successful completion were also issued. Full stop. The work was, however, visited by the Honorable Union Minister of State, Road Transport and Highways, and certain concerns were raised on the condition of the road stretches. Full stop. The respondent number 4 had informed the petitioner that on 27/3/2026, certain samples were collected and the petitioner had requested for supply of duplicate samples for independent testing in terms of the contract agreement, which, however, was declined. Full stop. The respondent number 2 had forwarded a report of the Assam Engineering College Consultancy Cell alleging deficiency in the binder content and had directed the petitioner to undertake rectification. Full stop. However, the petitioner had independently collected samples and got those tested, TSTED, at an NABL accredited laboratory, and the test reports dated 30/5/2026 had confirmed that the standards were maintained. Full stop. Accordingly, the petitioner had submitted a representation enclosing the said reports on 5/6/2026. Full stop. However, on 9/6/2026, a show cause notice was issued, which was replied on 13/6/2026. There was also a pursuant hearing on 26/2026, in which the petitioner had produced the test reports which had confirmed the binder content values, which was within the prescribed specification. Full stop. However, while the impugned order dated 26/2026, the petitioner has been debarred from participating in tender process for a period of 1 year. Full stop. It is this action which is the subject matter of challenge in the present writ proceeding. Para. I have heard Sri K.N. Chaudhary, Learned Senior Counsel for the petitioner, assisted by Sri R.M. Deka. I have also heard Sri B. Gogoi, Learned AAG, representing the Public Works Department. Para. Sri Chaudhary, the Learned Senior Counsel, has submitted that the impugned action is in violation of the norms as laid down in the guidelines forwarded by the communication dated 23/2/2018 by the Ministry of Road Transport and Highways, Government of India. Full stop. He has specifically drawn the attention of clause 8 of the said guidelines, which requires the state PWD to evaluate the bids which are up to 5 crores as per the ministry's extant guidelines. EXTNT, huh? He has also drawn the attention of the of serial number 5 of the communication dated 6/10/2021 containing the nature of the action which can be taken against a contractor for a kind of deficiency, full stop. He has submitted that as per the prescription given under under serial number 5, comma, in the failure to complete rectification, comma, the debarment can be made till such rectification is completed, full stop. He has submitted that in the instant case, however, the debarment is specified to be for a period of 1 year, full stop. He has also drawn the attention of this court to the requirement of an approval by the Director General within bracket RD and SS in respect of NH works as provided in paragraph 6 of the said communication, full stop. He has specifically submitted that no such approval was granted by the Director General bracket RD and SS, which is a requirement, full stop. The learned counsel has submitted that though the petitioner has grounds to be urged even on the merits of the action taken, comma, the decision-making process itself appears to be not in the manner prescribed by law, and therefore the present is a fit case for interference by this court, full stop. Para. 3. Gogoi, the learned AAG, on the other hand, has defended the action and has submitted that the impugned action is taken bona fide and in the interest of public service, full stop. It is submitted that before the impugned action was taken, comma, the samples were tested in the prescribed laboratory where the binding component was found to be shortcoming, full stop. He has also submitted that the petitioner was given the opportunity, including personal hearing, whereafter only the impugned decision has been taken, full stop. The learned State Council has, however, fairly submitted that the instructions do not cover the aspect as to whether any approval was taken by the authority mentioned in paragraph 6 of the said communication, full stop. He has also submitted that though the blacklisting is for a period of 1 year, comma, there is no dispute to the prescription that such blacklisting can be till a period when the rectification is done, full stop. Para. After hearing the learned counsel for the parties, comma, this court is of the opinion that instead of going to the merits of inter se merits of the respective parties, wherein the scope of such, wherein such scope is also limited, comma, there appears that in the decision-making process itself, comma, there is a violation of the prescribed norms, full stop. It is not in dispute that the ministry's guidelines would be applicable as per the communication mentioned above, which amongst others requires an approval of the Director General within bracket RD and SS, full stop. As observed above, comma, there is nothing on records which would show that such approval was indeed taken from the said authority, full stop. In view of the above, comma, this court is of the opinion that the impugned or action is not sustainable in law and is accordingly set aside, full stop. The respondents would, however, be at liberty to take appropriate action by strictly following the law, full stop. While doing so, comma, the prescription laid down that such blacklisting can be for a period till rectification is done, as provided in serial 5, would also have to be taken into consideration. Full stop. At this stage, comma, 3, Chaudhary Dulani Senate Council has submitted that in the meantime, comma, while a communication, in the meantime, comma, a communication dated 1st of August 2026 has been issued, whereby in terms of the blacklisting order, comma, the registration of the petitioner has been suspended. And this fact has been brought on record by way of an additional affidavit. Full stop. Para. Though Sri B. Gogoi has raised the issue that such order can be the subject matter of a fresh challenge, comma, this court is of the opinion that the office order dated 1/8/2026 as enclosed in the additional affidavit filed on 3/8/2026 is only an offshoot, is only a consequence of the principal order which has already been interfered with. Full stop. Accordingly, this court is also of the opinion that in a writ proceeding, comma, connected facts can be brought on record by way of additional affidavit, which would be treated to be a part of the pleadings as held by the Honorable Supreme Court in the case of AR 1963 Likhidima. In view of the above, comma, the consequential order dated 1/8/2026 also stands set aside. Full stop. The petition stands allowed in the manner indicated above. Sri Lala Puliata Sileto, my dear. Okay.
Mentioned in the morning by the respondent, my lord, there was a previous interim order, if it may be continued, my lord.
What do you want? It's been typed or some style was it? Let लीजिए, हाँ? Okay, we'll see.
Much obliged.
45.
My lord, I kindly see page 107 interim order, last part of the directions. The order contained 2/12/2024. From bottom, the lines are the entire exercise. Page 107, my lord.
R5. AK Ghosh has appeared for R5. Mr. Dr. for?
My lord, actually, what happened, my lord, after respondent number 5 was implemented, my lord, but as per office note, my lord, the petitioner have not filed, my lord, the up to date, my lord,
Post title.
Post title, my lord.
My lord,
That
we
is
have
why they have not accepted the wakalat number.
My lord, we have approached before the registry to file our course title, but since there is no specific direction, therefore they decline to accept, my lord, as per my instruction.
What direction is not there?
My lord, about the submit of the amended course title, my lord.
Because of that, we have the
Which-
wakalat number, but we
Which
and in the meantime, my lord, respondent number 5 has also transferred. New incumbent has been.
issue notice to the newly implemented respondent number 7, 5, which was
Which
allowed by which order, Mr.
My
Chamaria?
lord, the last order, this order.
No, the implement was allowed by which order?
My lord, in I, my lord.
Assam, I?
Anamika Tiwari.
2022.
But she's also not there now.
No, no, my lord, this is a third party, my lord. We are facing, my lord. My lord, may I submit only one thing, my lord? As per my lord information, they have conducted certain inquiry. Now, if my learned friends only submit the inquiry report, but I think that will sort out the, if suppose report is my positive.
After the inquiry, my lord, as per last instruction, my lord, the principal of Assam Engineering College was requested to go through it, my lord. Thereafter, we don't have any instruction.
Therefore, my lord, if suppose anything, my lord.
There is an order of memo of parties.
My lord, memos party there, therefore, my lord, we approach, my lord, after.
No, why don't you show this order 18/5/2026? There's an order, you don't follow the order. Learned counsel appearing for on behalf of the parties directed to file a fresh memo parties. It's a clear order.
Now present this is Srishti Singh, my lord, IAS.
Why should will the other also registry will not refuse?
We newly that incumbent, that name is my lord Srishti Singh. She has joined as a deputy, my lord.
That's a different matter.
Absolutely. my lord.
IA 1552 of 2026 was allowed on 18/5. And our R5 was directed to be implemented.
My lord.
Yes, now what for further change is there? And in the meantime, you obtained the.
My lord, I think that will suppose the report is in my favor, my lord, nothing.
Three
sir.
S. Chamaria, learned counsel for the petitioner, as well as Sri S. Datta, learned counsel for the respondent number.
Respondent number, my lord, I'm
Five.
1, 2 and 5. 1, 4 and 5.
1, 4 and 5, full stop. It further transpires that, and then it transpires that there is a further change of the incumbent holding the post of
District Commissioner, Morigaon.
Huh?
District Commissioner, Morigaon.
District Commissioner, Morigaon. Full stop. Morigaon after allowing IA Civil number 1552 of 2026, wide order dated 18/5/2026. While the learned counsel for the petitioner would take steps to implement the present incumbent holding the post, Sri Datta, the learned counsel for the respondents would obtain updated instructions regarding the steps taken towards compliance of the order in question. Full stop.
If lordship specifically mentioned, they have conducted inquiry for civil.
Question including the outcome of the inquiry.
One.
Full stop. List on 26th of August.
My lord.
You take steps in the meantime. Mr.
Yes, madam.
46.
14 matter.
Yes, my lord.
IA for?
Yes, IA for implement, my lord.
Implement.
My lord. In this matter, my lord,
14 is still pending.
read petitioner and
14 matter is pending.
read petitioner and my lord,
Pending.
well, read petitioner and private respondent already they have settled this matter outside of the court, my lord. It is final stage, my lord. Some time may be given. In the meantime, we will complete the process, my lord.
Are you aware?
Actually, yes, I am aware. Actually, we were the petitioners earlier, my lord. They have taken
Understood.
over
You are the writ petitioner.
Yes, yes.
He wants to get himself implemented.
Yes, yes. No. They were implemented. Now
Already
what happened,
implemented.
my lord? Respondent number 4 died in the meantime. They want to get one substitute.
Substitute.
Years of the respondent number 4.
Where is your IA? IA for what?
IA for
Substitution.
Substitution. Not implemented.
Substitution, my lord. Substitution of the respondent number 4, my lord.
Who is Barbhia? SR Barbhia?
Yes, our associate. my lord.
No. What is this order? I have not. Sri SR Barbhia, learned counsel for the applicant writ petitioner, has submitted the steps were taken for service of notice of respondent number 3, 4A, 4B. S. Chauhan. Ms. S. Chauhan is your colleague.
Yes.
Huh? No, I think this order was not properly. He is not for the writ petitioner.
Yes,
Yes, I am for it.
He was a read petitioner number. He has been implemented petitioner number 3.
3.
No, original writ petition was by whom?
By Vodafone.
Vodafone.
No,
They have taken over all the responsibility of
No. How is he the writ petitioner? He is the applicant. 1/6 implement.
implement has been allowed.
Now, how come he is the writ petitioner?
That day he filed his application for implement as a
Implement.
petitioner. My lord, he wants to take two in my.
You cannot be a writ petitioner. You can be an intervener. You can be a pro forma respondent. How can you
No,
replace a
Vodafone-
petitioner?
Earlier, read petitioner was Vodafone, my lord. Vodafone, all assets and
You can have an interest,
Yes.
which is same as but you cannot be a writ petitioner. Either you file a fresh petition or you intervene. How can applicant be a petitioner? How do you replace a petitioner?
Already, my lord, matter is, my lord, going to be settled, I think, whatever I messages.
Pursuant to order dated 2/5/2025, my lord, in IA number 912/2020.
912. What
912.
happened in 912? By which order, in which case you are transposed as writ petitioners? And where does Mr. Sharma go? What is this kind of proceeding you are initiating?
I already settled the matter, my lord.
That's a different matter,
My-
but you have not followed the proper procedure. Okay, what do? You adjourn it?
No, my lord.
Huh? Do adjourn the matter to have the settlement?
Yes, your lordship, for 1 month, I think, they are going to settle this matter. Everything is good, it's final.
Okay. Heard Sri A.K. Azad, learned counsel for the applicant. Also heard Sri M. Sharma, learned counsel for the original writ petitioners. Para? Sri Azad, the learned counsel, has submitted that steps are on for settlement of the matter, for settlement of the dispute, and he accordingly prays for some time. What's the para? In view of the above, matter is adjourned to be listed on
Second week of September, my lord.
second week of September. We have on the 14th of September.
My lord, my lord. Obliged.
TCR has come. TCR come.
My lord, have instruction to appear for respondent number 2. So I need some time to file the power and also to file affidavit.
Affidavit will be required,
And my lord, I should not, let me go through the brief, what is there.
if so advised. Okay, heard Sri S. Chakraborty, learned counsel for the petitioner. Full stop in this case. Notice was issued on 13/5/2026, pursuant to which Sri Mr. Das, you appear for whom?
Respondent number 2, my
A. Das, learned counsel, has submitted that he has been instructed to appear on behalf of the respondent number 2, and accordingly prays for some time to file the formal power as well as affidavit, if so advised. We can admit this then? We have to examine otherwise. Issue rule. List. Since the records of the tribunal have been received, list for orders on 26th of August to fix a date of hearing. In the meantime, pleadings may be exchanged if so advised. Last week, too. Going to timing go to hearing. It to hearing. Admission take korilo. Admission take korilo. 43 kar asil. Just a minute, Mr. Sir.
43, I think 43.
What was 43? Mr. Ali was here. What was the matter? Now, if this hearing takes place, your matter will not reach if it continues. Well, you can't help them. Where is Mr. Ali? He should have been here. Yes, Mr. Hello.
My lord, in the year 2007, my lord, the government of India announced an industrial policy which you'll also find at page 23.
Yes.
And you'll also find at page 24.
Who, you're for the other side? Okay.
We have filed the affidavit Friday, which is on record.
Yes, obviously you've served upon Mr. Dr. Saraf, I think.
Yes, Malak.
Affidavit you have received, Dr.
Yes, yes,
Saraf?
Malak.
Okay.
But at page 24, clause 3, my lord, at the bottom, interest subsidy. Interest subsidy will be made available at the rate of 3% on working capital loan under the NEIP 2007 as available under the NEIP 1997. So there was no time limit fixed for the purpose of grant of the interest subsidy. Now, to give effect to the said industrial policy resolution, a scheme was framed, which you'll also find at page 28. And the scheme also does not provide for any limitation period for the purpose of the grant of the interest
But
subsidy.
is this issue pending in the Supreme Court?
No,
Interest subsidy?
no, my lord.
In one of the
That
matters.
that was the matter, my lord. That was the most substantial expansion. Whether substantial expansion, the full will be granted or.
No, even for interest subsidy, the other day, we had adjourned a matter for 2 months.
The interest subsidy, there is no matter pending. So far, my knowledge goes.
Yes, Dr. Ankit, yes.
What is the matter?
Yes, he has given the SLP number also.
Yes. Because here my point is altogether different. My point is only on limitation.
No, that exactly on limitation.
And that has already been decided by this honorable court. 3 judgment. There is
No,
no.
he also he has made the same submission.
My lord, who has filed the appeal, my lord? I don't know. Because in my case, the division bench, they have not gone to the division bench. How the SLP will be there?
No, not in your case, some other case.
But the division bench judgment is
No,
not there.
not necessarily from,
Lord,
I
if you
don't
lost-
know.
if you lost
The interest on the interest subsidy. Sorry, the limitation period on the interest, since no limitation is prescribed. Can we have Dr. Ankit to the
number lost.
I think last week only we had this, therefore I remember. 28 July.
Then let me check up my better. Because then there must be a division bench judgment also.
Yes.
If they have gone to Supreme Court.
Yes.
So I'll find out.
Now he has given the SLP number also.
SLP number, the division bench judgment will also be there.
Definitely SLP.
So naturally I have to check up whether the same matter was there.
If he's in the court, we can have him.
Because in that case, what is the name of the party?
We can give you the details. It was on 28th of July.
Find out.
No, it is on 28th July. Key number, Asan?
Huh?
He didn't serve us.
Ishwar food.
So that was I remember now. There was judgment of the division bench, the Justice Barua. That issue was altogether different. Although I will find out and give you a loss of judgment also, Ishwar also, There the guidelines were issued subsequently. And the issue was that whether it will be retrospective or prospective. I will give the loss of the judgment. So far I remember that was a transport subsidy bill. Let me check up.
You may be correct.
Install food products was a transport subsidy matter.
No, interest on delayed payment.
That was different altogether, my lord. I have no connection. Interest on delayed payment under the act. I am not, my lord, concerned. I don't know how he has said.
Maybe that's a different matter. Issue maybe may not be exactly the same issue. But somehow I remember that
My lord,
may
if he-
not be the same.
If he has submitted, my lord.
No, he might not have submitted. Maybe there was no issue raised by the petition related payment. I think that was on interest on delayed payment. May not be.
Delayed payment of the subsidy amount, my lord. The earlier, my lord, there was judgment of this on.
No, interest.
Interest.
Yes, interest.
Earlier, there was judgment of this on the court.
Okay,
That-
here you're on the aspect of
No, no, the
interest
delayed-
subsidy,
delayed
whether there
submission-
is a limitation.
Delayed submission of the claim. My lord,
Okay.
as per the scheme and the policy, there is no period prescribed.
Hmm.
Now, the petitioner submitted his claim for 2013-14 after establishment of industrial unit.
Hmm.
And my lord, that was received on March 2016.
Hmm.
Now, there was disbursement was not made, so we approached this honorable court, and this honorable court directed the respondents to consider the claim and pass necessary orders.
Yes.
Subsequently, below the claim was rejected on the ground that it was delayed, expiry of the time period prescribed in the circular.
Okay.
Now, circular provided for Milord a period of 365 days, tentative period, Milord, 365 days from the end of the period, that is from 2014 to within 31/3/2015.
Hmm.
Now, only on that ground, Milord, the claim was rejected. Now, similar provision claim were rejected, Milord, the transport subsidy also, as well as the central investment subsidy. And the matters came up before this honorable court, and this honorable court held that no, the period of limitation for subsequently filing the claim is not there, and this is a scheme for promotion of the industries, and the 1 year limitation cannot be prescribed for that. And first judgment, when it was passed, Milord, then the claim was directed to be allowed, to be examined on merits. Then subsequently, the second judgment came where the earlier judgment was referred to, and that was allowed. Again, the third case, Milord, the case came up, and both the judgments were considered, and thereafter the claims were allowed. That's why I've given the compilation to your lordship, Milord.
Which compilation?
Milord, a judgment compilation was given, Milord, on the last occasion, Milord. I can give an extra, Milord.
It will be here if you had given. Asani give a judgment or compilation.
Judgment could go.
No.
You can give an extra, Milord. One is also stored food products, Milord. And you'll also find at page 6. Para number 18, Milord.
Para number 18.
18.
Yes.
The transport subsidy scheme is a part of the government of India, government in initiating to encourage the industrialization in what are called the lesser developed region of the country, and thereby accelerate the economic development of the such areas. Objective of such scheme being beneficial, reasonable, and liberal approach is required to be taken while implementing such scheme. Of course, the implementing agency have to be alert to ensure that bogus and stale claims are not entertained. This court understands that the time limit for the 1 year prescribed by the authorities for grant of the transport subsidy is for administrative convenience and to eliminate the belated claims or claims which are not genuine. This time limit of 1 year as prescribed is not too inflexible rule and is to capable of the scuttle the relaxation in appropriate situations. So this was the Milord observations made by this honorable court in this judgment, Milord.
Yes.
Now next, Milord, at page 8, the judgment is there, Milord. And at Illustracy page 22. Paragraph 18, Milord. The same observations, Milord.
Page 22.
Page 22, para 18.
That is
The same, Milord, has been reproduced, Milord.
that hasn't reproduced.
But-
Ishwar has been reproduced at
But
20.
this is the observation of the, although it is mentioned, but by way of an observation of the court. Then the third one you'll also find,
No, in such way, this court had observed.
my lord,
It is the reproduction.
reproduction, my lord, coming to back to the case in hand,
Hmm.
it is clear. Now you'll also see this one,
Page
page para 18, my lord.
para 18. Para 18 is this is Ishwar.
My lord,
18 is a part of the Ishwar.
now you'll also see thereafter at page 25, para 25.
Yes. 25 is the paragraph.
Observations.
Yes.
Where after 5-6 lines it says, this court is of the considered view that a genuine claim of
Yes.
an industry applicant for transport subsidy under the transport subsidy scheme 1971 is not to be rejected for a reason which is not attributable to the applicant, as the subsidy scheme so and so.
Your substantial claim is for what? Transport subsidy?
Interest subsidy, my lord.
Interest subsidy.
My lord.
These are matters of transport subsidy, wherein a similar
my lord, 1 year.
that 1 year period was there.
My lord, my lord.
Since it all are in connection with the policy of
Interest of
2007.
My lord.
So you want to say that the principle which is
My lord.
been adopted by this court so far as another subsidy is concerned,
My lord.
in a similar circumstances, so far as interest subsidy, is similar principle may be adopted.
I may not right. My lord, third case you will also kindly see, my lord. The page 25.
Yes.
And the observations you'll also find page 29. Paragraph 9, where the, my lord, the earlier two judgments were referred,
Hmm.
and thereafter at page paragraph 10.
Now, do you have any judgment on this interest subsidy?
My lord, this is, I think,
These are all on interest transport subsidy.
now this was a case under, I think, this was.
These are all transport subsidy. 1 year.
But the principle, my lord, whatever is there, my lord.
But
interest-
no case on
No, my lord. But the interest subsidy, also transport subsidy, also same scheme, same 365 days for limitation for filing the appeal, the claim. And on that ground, my lord, it was said, and in this judgment, my lord, para 10, my lord.
That means on the working capital loan under the scheme, you will be entitled
to
3% interest subsidy
3%.
at 3%, at the rate of 3%.
My lord, so far as I'm not asking for any whether the amount will be eligible or not eligible. They have not examined the issue at all. The claim has been rejected simply on the ground that the claim was submitted 1 year delayed. Now, my submission for lawsuit is that, my lord, that issue, the submission of the claim by 1 year, that has been examined in the case of transport subsidy, and which was also framed in pursuance to the industrial policy resolution of 2007. Now, central investment subsidy also, my lord, has been framed in pursuance to the industrial policy of 2007. Now, you also may kindly see para 11, my lord, of the third judgment, my lord.
Yes.
In view of the decisions of this court, whatever which are attained finality as on date, the respondent authorities are directed to reconsider the claim of the petitioner for grant of transport subsidy in terms of the transport subsidy scheme. If the petitioner claim is genuine, the respondent authorities shall take necessary steps for relaxing the time limit and grant the transport subsidy to its entitlement, the entire process so and so. Well, I am also praying that they may examine the issue on merits, and the petitioner is eligible for the grant of the interest subsidy, the same may be disbursed. Same ratio, my lord, there is no. So this is my three judgments which have not been filed in appeal also, my lord. The appeal has not been filed, they have attained finality. This is my submission for lordship. I'm not asking praying for, my lord, whether ultimately the amount will be granted or not. They will examine certainly. And if I'm found to be eligible, then the time should not come in the way, that the delayed submission of the claim should not come in the way in disbursing the amount. Like short, the para, whatever lectures are there, short note I prepare for your lordship convenience. These are. So the page numbers, etc., are readily available.
Yes, madam.
Because he submitted after we have given the breakup of that page 189 paragraph 5.
Page?
Just time by 189 paragraph 5.
You have filed affidavit.
Yes, madam. Flat C, madam. Lordship will find that flat C.
Flat C is your affidavit.
Madam, check it.
R4. R4.
Yes. It's my additional director. Lordship. So that is that strictly in paragraph 4 also, that 3% central interest subsidy on working capital of MS Carbon Resources.
Page 1.
Page 189, madam.
Paragraph?
Page of
Yes.
second page of my
Paragraph?
paragraph 4, madam.
Yes.
So, I beg to state that 3% central interest subsidy on working capital of MS Carbon Resources under NEIPP 2007, and the date of online acknowledgement is 30/3/2016, which is beyond one preceding year of the last date of claim period. Hence, the claim is time-barred. Again, acknowledgement is we have managed, and the second paragraph, paragraph 5, we have given the status of claim of the unit for different period from DOCP is placed below. So these are the
only one period will disputed.
Yes, that 1st of April 2013 to 31/3/2014. That is time-barred, More claim for the period of 1/4/2000. That is the disputed.
The rest all clear.
It is the disputed period. Is time-barred as date of online acknowledgement is 30/3/2016. Falls beyond the mandatory 1 year limit. Hence, the claim has been returned back to GMDICC. That is our that as per guidelines stipulated in the aforementioned directives, all eligible units are required to submit their claims within a strict time limit of 1 year for the succeeding financial year of the claim period. So that's why that period is time-barred. So that's why we since it is a central government scheme, central government will pay the subsidy. No. I'm time-barred. We couldn't stand it because it's time-barred. And policy guideline is strict about that time. And the judgments, my lord, are, as your lordship has already pointed out, this is regarding transport subsidy, not interest subsidy, my lord. So it's not covered as per my submission, my lord. It's not interest subject. Subject is totally different, my lord. Transport subsidy and interest subsidy.
Please, your lordship. We have filed our affidavit in opposition, my lord.
Where?
In page number.
Which flag?
Page number flag. B, my lord, flag B.
5 and 6.
Yes, my lord.
By R 5 and 6.
No, my lord. Yes, 5 and 6. Yes, my lord.
Yes.
Yeah, we have stated in page number 133, para number 3, my lord. Page number 133.
Yes.
That it is humbly submitted that respondent that is Union of India notified Northeast Industrial and Investment Promotion Policy 2007, making it effective from 1/4/2007 by office memorandum dated so and so dated 1/4/2007 for Hilly State. In person to NEIPP 2007, the answering respondent is pleased to make the Central Interest Subsidy Scheme 2007 hereinafter referred as CISS 2007 by notification dated 27/7/2007, which provide interest subsidy at the rate 3% on the working capital loan advance or to them by the by scheduled bank or central state financial institution for a maximum period of 10 years from the date of commencement and production, which are located anywhere in the Northeast region comprising of state of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, and Nagaland, Sikkim, Tripura, with a view to accelerating industries development in the region. It is further submitted that aforesaid scheme had ceased to operate with effect from 31/3/2017, my lord. My lord, now, my lord, the claim of the petitioner, my lord, the petitioner
Yes.
the petitioner established in para number 4, my lord, manufacturing industries unit of calcined petroleum coke in Sirang, Assam, obtained registration under the Northeast Industrial Investment Promotion Policy 2007 by certificate dated 26/2000. Subsequently, the unit commenced the commercial product on 30/11/2012, my lord. Then, my lord, the petitioner submitted its claim for central interest subsidy amounting to rupees 78,52,657.6 in respect to the financial year 2013-14 only on 30/3/2016, my lord. The submission of claim was made nearly 2 years after the close of the claim period, thereby exceeding the prescribed 365 days limitation period stipulating to DPIIT guideline circular dated 16/9/2013 bearing number 16/20/2013 DBA to an year, my lord. That is, my lord, they submitted on 30/3/2016, my lord. Now, my lord, Honorable Tripura High Court, my lord, that is in I have stated in 135 page number 8, paragraph number 8, my lord. Page number 135, my lord. The Honorable Tripura High Court in Pran Beverage Private Limited versus Union of India WPC 848/2022 has upheld the mandatory character of 1-year timeline prescribed under NIPPP 2007. The court held the claim filed beyond the stipulated period are liable to be rejected unless condonation is specifically granted in exceptional cases after due recommendation by the state level committee and approval of the competent authority. The ratio of the said judgment squarely applies to the fact of the present case and reinforce that 365 days timeline under the circular dated 16/3/2000 cannot be treated as a directory or ignorable at the instance of the claimant. And the judgment is in page number 155.
155.
155, my lord.
Division bench.
Division bench, yes.
Yes.
That the relevant person in case number 171, madam. 171, page number, paragraph number 20, madam.
Yes.
As such, we find no basis to accept the submission of the petitioner that timeline for claiming CCIS would not apply to the claim made after revival of any IPP 2007. Industrial policies have a defined life period. Claims for exemption of incentive thereunder also need to be adhered to the prescribed timeline. Otherwise, the whole purpose of granting such an incentive or the exemption or concession during the period when a unit is either set up or as a new or is expanded would get the defeated. As such, industry policy is intended to ensure industrial growth in the backward region by promoting the entrepreneurship to invest in those areas. The reason for rejection containing in the order dated 3/9/2021 and the order dated 23/1/2024 passed in remand do not appear to suffer from any non-consideration of the material on record or non-application of the mind to be termed as an arbitrary asset. As noted above, the petitioner has not even made any semblance of the explanation as to why the claim was submitted after expiry of 1 year. This court is exercising its jurisdiction under 226 of the Constitution of India is required to examine whether the decision of the authority suffer from the arbitrariness or irrational due to the non-consideration of the relevant factor required to be taken into account under the principle of the reasonableness. The order dated 23/1/2024 passed after reconsideration of the case of the petitioner recorded that any IPP 2000 is a scheme meant to promote the industrial activity in the Northeast region. The scheme provides incentive to all new as well as existing units to go for industrial expansion and commercial production within 10 years from the date of notification of the 2007 policy for the period of 10 years from the date of the commercial production. The department has rejected the promotion subsidy on the ground that the claim was submitted after 11 days beyond the period of 1 year. It is further recorded that the interpretation of waiver by the authorities is necessitated when a position of the scheme is not clear and where there is no room for the confusion. The department ought not to venture overzealously and grant undue relaxation, as such relaxation may have far-reaching implications as other similarly placed units may also stake their respective claim and accept partially from the department. The petitioner also cannot claim ignorance of law, as it ought to know the procedural aspect involved in the scheme under which it is benefiting or expected to benefit that cannot be pleaded ignorance. Similar are the terms of the earlier rejection order dated 3/9/2022 that the claim and DIC has been received after 1 year from the date of registration under NHIPP 2007 or date of commencement of the commercial product. In absence of any explanation or any reason contained in the recommendation of the SLC by minutes dated 29/2019 explaining the delay in making such claim for CCIS beyond the period of 1 year required under clause 7 of the guideline on behalf of the petitioner. It would not be proper for the court to interfere in the matter, more so when the order of rejection dated 23/1/2020 passed under the passed upon the reconsideration after the remand by this court in WPC 848 of 2022 has not been assessed in this writ petition. That is the judgment of the division of the Tripura High Court, my lord, and it was dismissed, my lord.
No Supreme Court judgment.
No Supreme Court judgment, my lord. That is the judgment of Tripura High Court only, my lord. And here, my lord, and their judgment is the Supreme Court, though that the Supreme Court judgment. And they are relying the judgment of the High Court of the single bench of Ishar Food Products. That is, I think, single bench was. That is the judgment of the single bench of the Gauhati High Court, one. And another is my lord Imami, that is also my lord single bench order, my lord. Single bench judgment, but this is by High Court, but I don't have the Supreme Court judgment in this regard, my lord.
The Tripura is on which subsidy?
Tripura is my lord, that is the. It is on a claim for in case number 156, my lord. It is on a claim from Central Capital Investment Subsidy under Northeast Industrial Investment Policy as revised so and so on the ground delay. Transport now. This is the guideline of the council from a picture from the litigant policy and guidelines. This here is submitted the council.
But rules of interpretation on exemption in fiscal statute, how is to be interpreted? There are two views. One is expressed by three of our coordinate benches. One is by Tripura Division Bench. Now, neither of the views, the interpretation part has been discussed. In fiscal statute.
Fiscal statute, so far the charging provision is there, the strict interpretation is to be made.
Yes.
But so far the other provisions are there.
No, even for exemption.
Exemption also, my lord. The exemption eligibility part, there is no dispute. So far the eligibility part is concerned, the strict interpretation will be there. But so far as the other part is concerned, the strict interpretation is not there. Whether a person will be entitled to or not, that will be
There are many judgments in this regard.
There was division bench judgment.
No. Supreme Court has clarified.
Following the Supreme Court judgment only, if you'll also permit me, I may give a note on the judgments that the delay in submission of the claim, the court has said that the eligibility part is strict interpretation, but on the ground of delay, the claim cannot be rejected. The Supreme Court judgment was there, that was followed by the division bench of this only.
Supreme Court which judgment?
Well, I don't remember exactly now the Supreme Court judgment, but.
We can do one thing, we can have this day after tomorrow.
Lordship, kindly see page 129.
Madam, there are many, you have placed Tripura, it's okay. Yes. That's a mechanical exercise, but you have to apply your mind. There are Supreme Court judgments, not one, many. Landmark judgment, how do you interpret a fiscal statute?
So that there is no dispute about it, but so far as the delay part.
Now here is a scheme which is meant to give benefit.
Yes, my lord.
Now in that case, whether an entity who is seeking the benefit,
yes,
is he required to act diligently? Diligently means, is he required to make the claim within the time specified?
Yes, ma'am.
If it is not done,
Yes, ma'am.
Dr. Saraf is stressing on the point that don't put me out on the threshold, let me enter, then you examine on merits. I may not still make it on merits. That's a different matter. But if you do not allow me to enter the room for consideration, then that would be against the statute, which is basically meant to give an impetus to the new industries as per the policy of 2007. That is an interpretation which is possible and which can be accepted. At the same time, how do you interpret?
Yes.
If your lordship looks into page 129, page 129, mark
129, yes.
And the chart which is there,
in your petition?
In my petition?
Yes.
At page 128. In the bottom note, your lordship may see.
Yes.
In the bracketed figures are the expected timelines in the number of days.
Yes.
Now, my learned friend was saying that this is the mandatory. This is not mandatory. This is expected time limit, timeless. He issued
What is this 120 days?
120 days, my lord. This is a different. You'll also find the chart that after submission of the claim, how many period they will process it, and thereafter the further process is there. And this is never followed, my lord. The central investment subsidy is never disbursed within 365 days.
No,
And Lordship,
Dr. Saraf, there will be two aspects. One is non-disposal within 365 days. One is not making the claim within 265 days.
Well, three issues I'm raising before Lordship. First, the circular cannot go beyond the policy and the scheme. When the no time limit is prescribed in the policy and the scheme, the authority by way of a circular cannot provide for a time limit which is not there in the scheme. This is the first submission.
You cannot supplant.
Supplement.
You can supplement. This will amount to supplanting. When you say that when the policy has not prescribed any limitation by a subsequent scheme, you cannot bring in the aspect of limitation.
In the scheme also it is not there.
Not scheme, the circular.
My lord. This is the first submission which I am making for Lordship. Second, which Lordship asked me the pertinent question, my lord, about the delay that I will produce before Lordship the judgment of the Supreme Court, that if a person is eligible, then his claim should not be rejected on the ground of delay, which was followed by the division bench of this honorable court in the excise exemption, which is also under the policy. And that there was a delay in submission of the claim, and the court held that no, you cannot reject it on the ground of delay, and the department accepted it and thereafter disbursed the amount. Third, so far the interpretation of the policy and all the similar, so far the interpretation of taxing statute is concerned, my lord, it is settled law that the charging provision is to be interpreted strictly, but the other provision, machinery provisions, are not to be interpreted strictly. They should be interpreted in a way which affects the purpose and which carries the purpose of the main provision. Now, so far as the eligibility part is concerned, that has not come up for consideration for Lordship as yet. If I'm not eligible, I'm out. There the strict interpretation will be there. And the fact that the petitioner is eligible is fortified from the fact that other claims of the petitioner in respect of the same subsidy had been allowed. If the petitioner would not have been eligible, the other claims would not have been allowed at all. So other claims have been allowed for other periods.
What have you stated regarding the delay? Why could not you put the claim within the time? Even if accepting that there is no time limit as such, but putting the claim beyond 365 days, have you cited any?
I'm submitting. This was circular of 2013. Now, nobody was aware about this circular at all. So 2013 onwards, all the claims have been accepted after the delay of 2 years, 3 years, the claims have been accepted. Nobody was, exercising the powers. Now, 2013 circular, suddenly, they have provided for that, it is rejected on the ground of delay. The circulars are there, and it is, you'll also see the circular. It is neither marked to anybody, it is internal circular. Now, internal circular, how the person concerned will come to know that what is the internal circular among the departmental level.
It may not have the enforceability.
My lord, you'll also find the circular. No copy is marked to anybody. It is internal, because they wanted administratively among the department that this is the expected timelines so that it may be expedited. The purpose was genuine, but that does not mean that the time limit will be enforced and the claims will be rejected, which are genuine.
Madam, we have heard your senior.
Yes, my lord.
The views are, even without repetition, we have two sets of judgments.
Yes, ma'am.
3 by our coordinate benches, 1 by a division bench of Tripura.
Yes.
The principles would be the same.
Yes.
Principles means the aspect of deciding whether it's transport subsidy or interest subsidy. How have it has been interpreted? What are the factors which have been taken into consideration? On the one hand, it's a policy which is to give impetus. It might go in favor of the petitioner. On the other hand, you might state that they were not diligent. The other factors would be that how much legal enforceability this circular would have. when it is not circulated. And when the scheme or the policy itself does not specify any time limit, whether a time limit can be later on imposed.
One more, my lord, one more. In respect of central investment subsidy itself, the provision was that 3% is to be given. Now subsequently, my lord, in the case of substantial expansion, they came up with a circular guideline, my lord, that no 3% is to be given only for the loans for the substantial expansion. The matter came up before the Honorable Court. I will place before lordship that judgment also. And this Honorable Court held that no, this was not there in the policy and the scheme. You, by way of a circular, you cannot introduce something new which was not there in the scheme and the policy, and thereby the circular was set aside in quast. And that was not carried.
Yeah, I think we had come across this.
I will place before lordship the judgment also.
This we had come across.
And ultimately, my lord, the policy and the scheme has to be amended retrospectively till the date of the judgment.
Madam, we have it either tomorrow or day after. Day after tomorrow.
In the meantime, my lord, I prepared the
Yes.
3-4 judgments.
We'll need some assistance from you also on the interpretation part.
And my lord, all the 3 judgments, that the delay cannot be a ground for my lord, this one. And so far, the interpretation of statutes also, my lord,
Yes,
the
interpretation part.
how it is to be interpreted.
Okay.
Well, I place before lordship.
Heard Dr. E. Saraf, Learned Senior Counsel, assisted by Sri P.K. Bora for the petitioner. Also heard Miss A. Gayan, Learned CGC, and Miss U. Das, Learned State Counsel. Full stop. While Dr. Saraf, the Learned Senior Counsel, has relied upon 3 judgments passed by coordinate benches of this court to buttress his claim, Miss A. Gayan, the Learned CGC, has relied upon a division bench judgment of the Honorable Tripura High Court, wherein such claim has been rejected. Full stop. As the matter would require certain more deliberation, including the aspect of the interpretation of fiscal statute, on the request made, the matter is adjourned to be listed on Wednesday for further consideration. Wednesday, you're okay?
My lord, maybe that after the 2 or something, my lord, usually accommodation.
No, we'll accommodate, definitely, whenever you're free.
My lord. In the meantime, my lord, I'll prepare a complaint.
Yes, please do.
Judgment. In fact, I missed it, otherwise I'd have placed the judgment of the.
Yes. Madam, it's a subject where you need to do some research.
Yes,
It'll benefit you.
We'll take the email address, my lord, we will also forward the
Yes,
copy
yes,
of the
yes,
judgment
yes,
which
yes.
we are going to apply.
Yes.
I highly oblige.
Yes, number to Councillor, WPC. 774. Yes, Mr. Sir.
My
Yes, Mr. Ali, you are not there.
I'm sorry.
Other side, yes, madam. What was it? Yes, notice was issued thereafter.
Second time, madam.
It has spent its force. The asserment period is over.
Lordship.
Then now
Then,
they are
my
changed.
lord, they are not floating any tender, my lord.
No, there's how soon can you do?
Time will be required for that.
They are changing the mode to E mode. But in the meantime, how are you running it?
Committee form lords when the training has been going on.
Now, how are you running it?
Under 105 lordship.
By following 105 through yourself. His thing is that you should take immediate steps. His prayer is not unreasonable. He's only wanting that the process to start where he wants to participate. When can you come up with the instructions?
Prior to 45 days, they should take step.
Heard Sri R. Ali, learned counsel for the petitioner, para. Miss P. Thapa, learned counsel, representing the PNRD department, prays for some more time to obtain further instructions. She has submitted that training program is on for implementing the new method, new mode of settlement by e-tender. Full stop. She prays for and is granted how many days? 15 days time, 2 weeks time to obtain further instructions. 3 weeks time. Full stop. Para. Tendency shall not be a bar to initiate the tender process in accordance with law. Good.